Good afternoon. Good afternoon. It's Thursday, January 23rd, and we are going to live court in the state of Idaho versus Bryan Kohberger. The reason we are going to live court in the afternoon is because this hearing started in the morning and was sealed to the public, meaning no public at all. So we were waiting for the public portion of the hearing. There was a hearing that was emergency docketed yesterday on January 22nd, where a media coalition, through their attorney, the same attorney who's in the Idaho TikTok psychic defamation case representing the professor, same attorney, was in court via Zoom yesterday arguing that the public has the right to access all of these hearings. At the end of the day, the court said, no. So the hearings this morning were hearings with witnesses. And by this morning, I mean most of the day, local time, mountain time, before and after the lunch break. So they had multiple, I assume, witnesses testify. I would love to tell you what the witness list looks like and who testified, but it's also sealed. So the hearings today are regarding motions to suppress. What's interesting is going on in the Corey Richins case today is also hearings on motions to suppress. What does that mean? It means the defense has made their motions to suppress a whole bunch of evidence before this goes to trial, including evidence gathered from Bryan Kohberger's apartment, his Amazon account, his Apple accounts, anything taken in a search with the arrest warrant, anything from AT&T, all of his cell phone data, pen trap and trace data, search of his person in Idaho, anything from the search of his person in Pennsylvania, anything searched from the white Honda, things searched from a home in Pennsylvania, his Google accounts, and more. So they are trying to say, Your Honor, for reasons, and we're going to hear those today, for reasons, you need to suppress whatever law enforcement got from this particular search warrant, or thing. What we're not going to hear is what happened with the investigative or the IgG DNA. That was the sealed portion of the hearing. The court has said that is all going to remain sealed, that information could potentially taint a future jury, and it might not come in at trial. And by might not, it's not coming in at trial. The IgG DNA will not be a part of the trial. That is part of the investigation. It's like step one to how they get to other things, but it is not going to be evidence in trial. So the court has sealed all of that while they are going through those hearings. This hearing is likely to continue to tomorrow. It's likely that we will see additional law enforcement witnesses and learn more about the searches, the search warrants, and what happened, but not really more about the investigative DNA. That information, again, will not come in. Taylor in the chat asked a great question. Will the DNA itself be a part of trial? Any DNA from the crime scene that was tested will potentially be a part of the trial. I say potentially, it's most likely, but will potentially be a part of the trial once the judge either allows that in or not. After these hearings today, we'll know more. But we won't hear that initial part of the DNA and how we get to some of these warrants. That was the sealed part of the hearing. That's what we're not going to know about. The court has indicated they will unseal all of that after the trial and potentially later. So court has been ongoing all morning, sealed, and is finally now going public. So we are going to the public portion. There are a lot of motions. So we are going to go through all of those motions, and then we will see what happens at the end. Jeannie asked, without this, can they convict? Well, we don't know what this is with the IgG DNA, but based on what we know, ooh, something just hit my window. Terrified me, probably a bird. But what we know is with the IgG DNA, if the court finds an issue, then they may suppress anything that comes after it. So it can kind of knock out other evidence that if the court determines that's fruit of the poisonous tree, which means you get to step one. If step one's a problem, anything that comes after that step is also a problem. we don't know. I can't give you is that likely, is that unlikely? Because we don't know what the defense is arguing. We don't know what the witnesses have presented, and we don't know what's happening. It's unlikely that that will be an issue. That is an investigative technique. But if they do their investigation wrong, then the information that comes after should be suppressed. That is the remedy if law enforcement does things not following, the Fourth Amendment and other constitutional protections. So if there is a problem, then it can knock out the evidence that comes after. So we will see what happens. We will not get a ruling today, is my guess, because this court likes to issue written rulings. He's been pretty fast with them. We are again in front of the new judge. This case changed venue, so we are now in Boise in front of Judge Hippler, Judge H. Everybody's just getting an initial at this point because there are some judges whose names I can't pronounce. There are some that I can, but everybody's just getting an initial. So we're in front of Judge H in Boise, and we will go into that hearing. We're going to roll the intro. We have a thank you to a sponsor, and then we're going to get going. There are lots of other things going on in the world of law. Every lawyer, it seems, in the civil space is trying their best to get all of their billable hours for the entirety of 2025 done in January. Everybody's just like, you get a lawsuit, we've got new filings, we've got to say this. Like, everybody's back from the Christmas break, like, new year, new billables, baby, let's go. So it is busy. It's busy. But this is going to be a long day in court, and then we will see what happens at the end of the day and when we will be streaming tomorrow. I assume that we will be continuing in stream tomorrow. So if I know there are new motions, I know there are new filings in the Karen Reed case. There's a response in the Sarah Boone case. We're going to get to that a different day. We're not going to get to it today. And for all the members, we got to some new filings with Blake Lively's attorney last night. Ooh. So if you haven't caught our 4-hour members only live yet for the members, well, you probably caught it while you were waiting for this live to start as we were waiting on the court. So for that, I am incredibly grateful. If you haven't caught it, make sure you put that on your list because man, oh man. Northwest said, wait, there's something in Sarah Boone. The state responded to the motion for new trial, much in the way I responded when I read the motion for new trial originally. Don't worry, we'll break it down. The state response to summarize is, yeah, no. Law nerds, it's good to see you. Let me know where you're coming in from, what you're drinking. I hope you're staying warm. My fan has been working overtime in my office to keep me toasty because it is cold. It's cold here in Middle Tennessee. So, law nerds, let's get into it, shall we? It's time to go. Let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
So for all of you asking, and I saw many of you in the chat were, Emily, what are the EDB Air accommodations for the significant delay getting into the airport in Idaho? First of all, EDB Air would like to officially blame Judge H for sealing the proceedings. However, everyone will get complimentary beverage of their choice, and there is no need to upgrade because EDB Air is like a first class only. We're not packing everybody in. We're like a private airline. So everybody gets their own comfy seats. I think they should have like soft, plush, fluffy seats with lovely blankets that you can take with you and massagers. So snacks of your choice, drinks of your choice. Cheers. And apologies for the court's ungodly delay today. However, I'm not surprised at how long it took based on the fact that they were having witness testimony. And we're also going to have witness testimony in, I imagine, the rest of these hearings. So Yes, it is frustrating. Yes, I understand, but it is something that that we have to deal with because court is dynamic. Oh yes, your pawnards are allowed free of charge, though sometimes we will have to do pawnard flights and pawnard free flights so that we can accommodate our allergic lawnards as well. So we will have pawnard flights and pawnard free flights. But yes, we do not charge for your pawnards. They are part of the family. So yes, pawnards on EDB Air. All right, before we get into court, and we are going to court in just a moment, we do need to take a moment and thank our sponsor. Look, Baker Media is an independent media organization. We are largely supported by the Lawnards. We are also supported by a handful of hand-chosen sponsors for products that I use. This is a product that I use a lot. Is this a product that I use to get onto TikTok? No. Is this a product that I use to get into everything else I do in my life? Yes. Into A, it will help scan all my downloads to make sure that I'm not infecting the computer. B, I've made sure my parents put it on all their things because it will like alert them to stuff. C, all of my kids' devices. All of my kids' devices. And for those of you that have been around since before the Emily Show even changed its name, you know that Nord has been a sponsor of my show for years. So thank you to today's sponsor, Nord. And then we are going to court interruption free. A huge thank you to today's sponsor, NordVPN. You guys know that I have used Nord for quite a long time before they were ever a sponsor, way back at the beginning of this YouTube channel. When I look at sponsors for this channel, one of the things that is critical to me is how easy it is. And Nord makes it easy. Not only do they have privacy at the heart of what they do, including encrypting your traffic and not sharing your data, but they also have protection from malware and phishing scams. So Threat Protection Pro can help whether it's downloading a file or clicking a link, because you never know what everyone else is up to on the internet, even if you're being safe. And when you have the Nord app, you can enable dark web monitoring. So there is someone checking to see if your information and passwords are ending up on the dark web. And if you have any questions about getting up and running with Nord, they have 24/7 customer service to get you going. So if you are ready to get all the protection we just talked about, it is time to check out NordVPN, and it's risk-free with Nord's 30-day money-back guarantee. So get our exclusive offer, which includes 4 extra months. Just head to nordvpn.com/EmilyDBaker to get our exclusive deal. That's nordvpn.com/EmilyDBaker, or hit the link in the chat or the description, and make sure that your online activity is safe. Thank you for sponsoring Nord. Let's get back to today's stream. All right, y'all. Are you ready to go to court? Because it's time to
bring the jury.
I mean, it's not really a jury. Oh, but we didn't get to Idaho yet, Emily. You're correct. You're correct. There we go. We can't possibly be in Idaho. We have not transported ourselves there yet. And it goes much faster than an Animal Crossing, where it takes forever to get between islands. I know. So let's go to Idaho, see what happens today. This is the new court layout because the court streams to their own channel. We stream on a slight delay so that we can add closed captioning. A, it's important when I interrupt, and B, it's important for all of our lawnards that use those visual cues so that they can understand better, or because they just cannot hear the court as well as they would like. I also process information better when I can see it and hear it. So that's why we choose to restream it, so that we can add closed captioning, because the court doesn't. Though I've been tempted to email the court administrator and be like, hey, can you just turn on closed captioning on your YouTube channel too? That would be great. But we do it this way so that we can accommodate all of the lawnards, and honestly, so we can accommodate a little bit of Zoom room. That's what we need, truly, all the time.
We are back on the record in State v. Kohberger, CR 0124316665. We are now, I believe, streaming.
Yes, you are. Yay!
For the record, the defendant is present together with counsel, Ms. Taylor and Ms. Massoff. The state is present and represented by Mr. Thompson, Mr. Nye, and Ms. Jennings.
And they've been there all day.
We are now going to hear argument from the parties on the Frank's motions filed by the defense.
Oh, yay for us.
That will include the Frank's hearing that was held on the IGG issue, as well as the defense's proffer as to the rest of the Frank's issues as to why the court should hold a hearing on those matters. We're holding an evidentiary hearing on those matters.
So the court heard evidence and is allowing us to hear the argument, even though we didn't hear the actual testimony. So some things they might add, they might say under seal, but we will get to hear that. For all of you asking why it looks like the defendant is sitting down lower, he is in a different kind of chair. All the attorneys are in like wheelie chairs that have arms. He would be in a more fixed leg chair because I imagine he would also have leg restraints on, and those would be affixed to the chair. So he is in a different type of chair than the attorneys are. The attorney chairs can, up and down like an office chair. His is a fixed chair in court, and that might be part of why.
Am I missing something we talked about?
Honor, I may have missed it, but I thought we were offering argument on suppression IGG.
Well, the suppression IGG, we can also argue that. I think it's wrapped up in the same issue.
She's like, what are we doing? Immediately, what are we
I
doing?
thought we were going to Frank's next.
I did not. I apologize.
And Taylor's like, Your Honor,
Reference
what?
over here, Your Honor.
Well, do you want to argue suppression on IGG and then we can do the Franks? That's fine.
I would need 5 minutes to get my Frank's items ready.
She's not
Do
ready.
Argument on the suppression of the IGG related.
We'll talk about
matters,
Frank's.
and then we can then hear the Frank stuff. That's fine.
We'll talk about
That's
Frank's
what
when
you're
we get
prepared
there.
to argue.
Thank you.
Go ahead.
The court's like, the court is just going to be like, why isn't anybody ready? And the attorneys are going to be like, because you didn't tell me what we were doing. Damn it. We'll talk about Frank's in a minute.
Your Honor, our position is that the court
We're arguing suppression
should
of IGG.
suppress the IGG identification and everything that flows from that. This is supported by 4th Amendment of the United States Constitution, due process, Article 1, Section 17 of the Idaho Constitution. Your Honor, there was no warrant for several phases of the search that led to the IGG work, investigative genetic genealogy. And we think every single one of those stages, a warrant was required. None was given, and so this must be suppressed.
I mean,
Your Honor,
you
I'd
may
like to
think that.
identify the 3
I don't know if you need
stages,
that.
and they are when Idaho State Police Forensics Lab, through Moscow Police Department, moved a DNA sample to Othram Laboratories to develop a profile to run through genetic genealogy investigations. There was no warrant for that search for a SNP profile that could be used to attempt to identify somebody. The next stage
don't know
would
if
be
you need
when
one.
that was transferred to the FBI for their forensic investigative genetic genealogy work to try to identify somebody. No warrant was in place for that work either. Finally, there was a trash pull in Pennsylvania, and there was no warrant for that trash pull either.
I've got questions about
All
the
3
facts
of those
there.
stages of this case, there should have been a warrant and there wasn't, and this must be suppressed. Your Honor, for the purposes of the 4th Amendment protections and Article 1, Section 17 of the Idaho Constitution, we are looking to see if somebody has a
Trash can need a
privacy
warrant,
interest
depending on the
that
facts.
society is ready to support. In this case,
We don't know
if
all the facts.
society is not ready to support suppression of every bit of our DNA when the government does not have a warrant and searches it, there is no privacy right left.
Problem is we
Do
need
you
no.
have any cases that hold that?
We need
Do
more
not have any
facts.
cases that hold that, nor do I have any to the contrary that say that's not the case. Your Honor, this is a situation where this identification was done in complete secret behind closed doors,
That's how
and it's been
investigations
continued
happen.
to be a secret. And that should raise red flags for your honor about privacy interests that are at stake. The court
The
can
problem is a
see
lot of those
from the
aren't the
various
defendant's
affidavits
privacy
in this
interests.
case that there's a lot of things done that don't say how Mr. Kohberger was identified. And the reason for that is because nobody wanted to talk about what happened here with the genetic genealogy. That search was done by making a profile in Othram Lab. That search did not lead anywhere. The FBI took over the search, and from there they did things
Who
that we
took
have
over?
no idea what it is. That entire segment of this case is secret. We have been through several motions to compel to try to get information, and we've gotten very, very little information. The court should know that we learned today about policies and procedures of Othram that we have not been able to take a look at. Those have not been produced. In fact, we've been told they don't exist.
A lab should have policies and procedures, it would
We
seem.
learned about investigative work that was done after Othram had done the work that they could do and before the FBI took over, that we learned about for the first time this week. Not through the motion to compel process. This was a giant secret. When we get to the FBI, we don't know who did the work. You heard that any of that information is redacted. We don't know who did the work. It's a giant secret. We know that by the time the FBI gets involved, the profile, the text file, that's a snip to use to try to identify somebody is more than twice as big when it gets to the FBI from Othram. We don't know how. We don't have any notes. We don't know who did any of the work. We don't have any lab protocols. We don't have any quality assurances. It's not reliable.
You're not asserting that Mr. Kohberger's DNA sample was uploaded into any of those databases, that his was,
No,
like,
she's
for
not.
example,
That's why it's a problem.
his own DNA was one that was matched from the
No,
crime
that's
scene.
why it's genetic genealogy.
Not asking whether the crime scene DNA was uploaded, but whether he had as a, for example, customer
He
of
doesn't
one
have
of
a
these
Fourth Amendment right in
companies
somebody else's
uploaded his
DNA.
DNA.
It wasn't his.
Well, Your Honor, I
Right.
don't have the jed.com file. I don't have,
Right.
You're not asserting that fact, correct?
Your Honor, I'm not sure what the court is asking me.
Well, it goes to whether or not your
The
client.
court is asking whether or not your client has a Fourth Amendment right in somebody else's DNA, not his own.
has standing to complain about the searches of the databases
Bing.
because, as the state has posited, that wasn't his DNA that was searched. At best, it was his ancestors.
Well, Your Honor, I am not sure why we're
You don't
here.
wanna
if
rile
the
the ancestors,
state
but-
hasn't alleged that Bryan
The
Kohberger's
Constitution-
DNA was on the knife.
No, I'm not talking about the knife sheath DNA. I'm talking about what they tried to match it to.
Oh, the court's not having this at all.
Your
Court's
Honor, I
not
would
having it
answer
all.
this way.
Nope, court's done.
The way that those databases work is looking for shared DNA. Those databases don't churn out a name and say, this
I
is
have
your
a privacy
suspect.
interest against any of my relatives that might want to upload their DNA to
Nope.
one of those systems. I should be able to
Also, if
stop
you're going to
them
get up to
from doing that
fuckery,
because
tell
I
your
share
family
some
not to
DNA.
use
That is
DNA
certainly not what
services.
I'm saying. What I am saying, Your Honor, is if somebody
Also,
takes
for everybody saying, and I saw a lot of you in the chat saying, I thought that, Ann Taylor might be more prepared or seems to be buffering. This is a very difficult argument for her to make. She is representing her client in this. She has an ethical duty to the court, so she is parsing her words very carefully. She is making these arguments to preserve them down the road, but she does not have the facts on her side. And with this judge, she can't talk about the public policy interests in it because he won't have it. Judge would have listened to her talk about it all day and how people should have privacy rights and where society's boundaries of privacy is. And Judge H is like, but in this case, please, in this case, your client in this case. So this is not her. This is bad facts and careful argument because the facts are not on her client's side. It seems in this circumstance, because they are not arguing it was Kohberger's DNA in these databases, it is familial DNA. And that is where she is pausing. And I would rather have a lawyer pause to be careful than misrepresent something to the court.
Takes your DNA and uploads it. I think you have a privacy interest in your own DNA.
Not
But-
necessarily in, let's say my DNA is taken lawfully. What privacy
ding,
interest
ding.
do I have in the search of the DNA of others?
Correct. Correct, you don't.
That's a loaded question.
Why is it a
It's
loaded
not a
question?
loaded
Isn't it a
question.
factual question?
The facts are bad
Well,
for you.
It is, Judge, but you're assuming that the DNA was taken lawfully, and our position,
I agree that part is an assumption. In my hypothetical, I said my DNA
And we're not
was
there
taken
yet.
lawfully.
On whether Kohberger's
Why
DNA
would
was
I
taken
have
lawfully.
standing to object to the search of other people's DNA simply because I might share some genetic information with them because they are distantly related to me?
well, Your Honor, our position is that this work was not done lawfully, that it was unlawful, that there needed to be a warrant, that
That's a
this was
different
done
part.
outside of a warrant. And
It's a different part.
I'm not asserting on behalf of anybody else.
Yes,
in
you are.
this, any relative, anybody who might have been named or not named. This is about an identification process.
There's two parts.
It needed to be a lawful process.
There's two
It
parts.
wasn't.
Here's the thing. There's two parts. There is the DNA we have heard about on the knife sheath found at the crime scene, and whether or not DNA swabbed from Kohberger was taken properly. To swab someone for DNA, you need a warrant. That is a separate question from the genetic IgG DNA that was used to somehow tie him to something. So that is different than his direct DNA being taken subsequent to his arrest and then being used. So there are two different parts here. She's jumping to the second part, and the court's like, no. First part, it's presumed by me that the DNA they are mostly talking about is not random DNA from a database. We know the trash was taken from his parents' house. I would presume the DNA that they are fighting about was DNA lifted from the trash, taken from the parents' house, uploaded, and then compared to the DNA on the knife sheath, being like, well, this is pretty close familially. We now have another step to get an arrest warrant, and then went from there. Whether or not they need a DNA to get to the trash is much more fact specific. We will talk about that separately. It depends on where the trash was, how close to the house it was, behind a gate, blah, blah, blah. These are all law school, Fourth Amendment, where was the trash located, that matters. You can't always just take trash. It depends on where the trash is located, and we will get there. So it depends where we are on the trash, but we're going to hear about that later because they'll get there later. So don't worry. We will get full Trash Panda later on. We're not there yet, but we're just trying to talk about the IgG DNA, which a lot of you are mentioning you've seen from other cases. It is used in other cases. Oftentimes, law enforcement will follow someone around until they drink out of a cup or a straw or eat a pizza or whatever, and then grab it. This is a bit different.
A lawful process. It was in violation of Mr. Kohberger's rights. I don't know how he cannot.
How
have
was it in
standing when
violation
he's
of his
accused.
rights?
Excuse me?
How was it in violation of his rights?
That's the question.
Well, Your Honor, he's been in custody
You're
for
saying
2
that,
years.
I understand your position, which frankly is not well supported in the law, that if hypothetically here,
Yikes.
he went to this crime scene, committed these murders, and left DNA on a piece of evidence, that he now has the ability to object to that evidence being searched for identification purposes.
Doesn't.
There's no case that suggests that concludes that. And it seems to me to be an extreme position to take in light of the case law, and I'm trying to understand how you get there.
extreme's a strong
Well, I
word.
think Your Honor is asking me about things that I anticipated the state would argue, their abandonment theory. And I would remind the court that the Ross case said that
We're not talking
abandonment
about
is
abandonment.
a knowing intentional leaving of something,
She is
for one thing.
switching
For the other
arguments.
thing, I think that the court is asking me to
She's
take
not
a
answering him
position
directly.
where it feels like burden shifting to me.
No, I'm trying to understand the legal argument and how this is different from example from latent fingerprints.
Well, Your Honor,
I
I
like
think
this
that
judge.
things like latent fingerprints and like CODIS, there's statutes
I'm going to say
about.
this judge's method of engagement is much more like the appellate courts we've seen, where he's not going to just listen to her argue. He's like, I know what you're saying. I have heard what you're saying. However, I need you to answer my questions specifically so I can make a decision. So answer this question. So that's great when you have the facts on your side. That's not great when you don't have the facts on your side.
CODIS in Idaho, about what's allowed in CODIS. This is a different search. This isn't an STR search. That's what happens in CODIS. This is a different
So
search.
I'm going now to, I'm sorry, the constitutionality of using
She still hasn't
the
answered the
DNA
question.
that was allegedly on the knife sheath. And because I understand your argument is twofold. One, your client complains that a search was done of databases of other people to determine whether or not any of them might be related to the person who left the DNA on the knife sheath. That's thing one. Thing two is an objection to the law enforcement searching the DNA by testing it and getting a profile from the knife sheath without a warrant. My question goes to that latter point, understanding the basis for that, because I can't find any case law that would support that
There
idea.
isn't any. Because there isn't any.
That somehow a warrant would be needed
it's
for
not.
DNA left at a crime scene.
Well, I think in our briefing, Your Honor, that we cited the court to some cases.
I did, I think, one concurring opinion in a case that held otherwise.
No, they're arguing over whether you need a warrant to test things that are at a crime scene. And the answer is no. No, it is a crime scene. No, you do not. Things recovered from the crime scene can be tested without a warrant. Things with the defendant are different. The crime scene in this case did not need a warrant to take things out of the crime scene and then test them and swab them for DNA.
Your Honor, I was going to talk to the court about third-party data, and I was going to talk to the court about the Davis case that talked about something that the police lawfully had and a subsequent test, the Skinner case, when there's something that's lawfully held, but there's a subsequent test. So those are the things that I want to talk about.
He's like, I don't want to hear
Our first point
it.
is it was an illegal search. And
Not at the
this
crime scene, it
is
wasn't.
if
Search,
the
which
court's
search?
assumption,
Which search? It was illegal.
well, first the snip at Othram, then the snip at the FBI, and then the trash pool.
So you're talking about the DNA
The sheath.
testing of the material left allegedly on the knife sheath.
I'm talking about the Idaho State Police Forensics Lab taking a piece of
She's not
evidence
answering
given
his
to them
question.
by Moscow Police Department, collected at
She's
the
like-
scene, developing a STR profile,
continues to
uploading
punt.
it into CODIS, and I think that's the King case that says that's fine. I know Idaho has statutes on CODIS, uploading it there and producing nothing. There are no results there. I'm talking about the next
There don't
set
have to
of
be results. That's why
moves
they got the IgG.
that are super secret, that happen when there's a portion of the DNA taken
Oh, but that's not your
and
client's DNA.
it's searched by Othram to create a SNP. And then when that doesn't produce anything, the FBI says, okay, here we go. Let's search the SNP
Thank you, Miguelina, for putting up our BRB screen. Sorry, chat. StreamYard crashed and just booted me right out. When I say we are in the middle of working on our own solution, we are. For all of you that are going to ask, Emily, was it your internet? No, it wasn't, because I could still message you in the chat. StreamYard just was like, oopsies. Court's dynamic, streaming is dynamic. StreamYard's like, girl, you've streamed for like 30 hours this week. We done with you. So the court is asking incredibly specific questions, and Ann Taylor is trying to redirect those questions, and that's not going great for her. So let us just swoop-a-doop and return to court, and hopefully my heart rate will resume a normal rate, because my Apple Watch is now beeping at me. That's where we're at. Thank you for your patience during our technical difficulties. Everyone's going to get another drink voucher and some snackies.
As far as asserting family,
Specific DNA tests done of the sample that goes from legitimate to illegitimate?
yes, Your Honor, I think the Davis case is on point. If
Court disagrees.
If the court's theory that this is a lawful piece of evidence taken from the crime scene, the sheath,
My theory, I'm just trying to understand your position in light of the case law and in light of the state's arguments. I'm trying to find where the gristle is in this.
I'm adopting the court's hypothesis for this purpose, that the knife sheath was taken. I'm adopting it only for that purpose, and I'm relying on the Davis case that says subsequent searches need a warrant.
And remind me, Davis was the cell phone?
No, Davis was not the cell phone. Davis was blood, a sample with blood. The cell phone case is
Give me the
Carpenter.
site to that.
I'm sorry?
Can you give me the site to the Davis case?
And 2 seconds. 2 seconds and glasses.
I mean, girl, fair. Let me get my readers. Fair. So for all of you asking, look, Ann Taylor is making difficult arguments that are not well taken by the court. They are not seemingly well supported by the facts. I say seemingly because we don't have a complete record that's
Apologies, 'cause
public.
My memory tends to be fact-based and not name-based, and so that's my liability.
Well, it's
Your
gonna take me
Honor,
just a
I
second.
feel so
apologize.
seen. I have never heard a judge actually acknowledge my memory is more fact-based
I
than
apologize.
name-based.
I wrote the name down, but not the.
Me, that's me. There are lawyers who are incredible at this case, this page, this line, this judge held this. My brain doesn't work that way. I will remember facts like they are song lyrics. It's, oh, the case where this thing happened. I could not tell you what judge wrote the opinion, what the name of the opinion was, any of it. I think a lot of people can see the image of the case they read, like in their mind, and then they can just see that information. I have no mind's eye. I cannot do that. My brain remembers dialogue, and the facts are the dialogue. And I've never heard a judge say, my memory is more fact-based. I feel so seen. Thank you,
cite
Judge H.
in my notes, but I know it's cited in our briefing. Can't remember what
I love it. I'm here for it.
It is 690 F 3rd.
So he was asking her for the
226.
site.
All right. And so those are the three areas that we believe that there should have been a search warrant and there wasn't. There is an expectation of privacy in one's DNA that society is willing to recognize. And I think I'd talked to the court a little bit about the things that happened in this case that were super secret. I think we'd gotten to the point where we were talking, and this goes to recognizing an expectation of privacy when there's all of this secrecy surrounding it. We had gotten to the FBI where the SNP profile was twice as big as that from Othram. And then the FBI went into databases that violate the Department of Justice interim policy. You heard a lot about that Department of Justice interim policy, and that policy it's on page 6 of that particular exhibit that the court has. It says that they're not to go into databases that aren't allowed. And they did that. The court has that in another exhibit.
How's that a constitutional violation?
Your Honor, it goes to privacy.
You know, suppress for contractual violations or even statutory violations.
I'm not suggesting that we do that. I'm suggesting that that's information that's pertinent to this court in making a very important decision as to whether somebody's Fourth Amendment rights were violated, as well as Article 1, Section 17 of the Idaho Constitution. The purpose of offering that information is because there's a policy, so there's a recognized expectation of privacy in what's contained in a SNP. In a SNP at all, there has to be a warrant to search these types of things, and there wasn't.
No, there doesn't. Not
would
if it's
be
not
no
your
need
clients.
to have any policy if
If
nobody.
it's not your client, somebody else can come in and complain. And a lot of you are asking very good questions about warrants. Look, criminal procedure dealing with the Fourth Amendment is like an entire class in law school. It is not always an easy, quick answer, and it is an in-depth area of law, and the case law keeps changing. In this argument, she is arguing not about taking Bryan Kohberger's DNA from him. She is arguing about creating a DNA profile from evidence at the crime scene and then testing that against databases and then testing that against IgG DNA. So she is not arguing his DNA at this point. It's the DNA taken from the crime scene and made into a SNP or a profile, and then the DNA run against databases. So this does not go to her client's DNA at this point because it was unidentified DNA from the crime scene. Taking DNA from Kohberger, from swabbing him, different situation. Swabbing evidence at the crime scene, not something that you need a warrant for. So that's, and she keeps shifting the argument a bit, and that's not going to work. So the court's going to probably shut this argument down shortly because he keeps asking pointed questions and she keeps not answering.
Cared about this. The court heard about the different IgG databases that changed their rules in terms of use after a different case used IgG to solve it because people don't expect to have their DNA searched.
That was the point of my question about whether or not Mr. Kohberger's DNA was in any of those databases. In other words, did he submit his DNA and said, I don't want law enforcement to look at it?
And it wasn't.
Your Honor, I don't think that that's the way the question should be looked at. I think the question should be looked at in the way that we always look at warrantless searches.
Got to be a standing.
Yeah, he's back to like, well, there's this
Your Honor,
little thing.
We're here
Called
because
standing.
the state has alleged that a single piece of evidence ties Mr. Kohberger to this case.
Is it really
They've
just a single
alleged
piece?
that there's a knife sheath that has DNA that they allege matches Bryan Kohberger. He's now been incarcerated for 2 years facing capital murder. I'm not sure, unless we're shifting the burden to me, what else I can say.
This is your emotion. The burden's on you for your emotion,
Well,
though.
you have a burden of showing that the items ought to be suppressed.
This is a warrantless search. There's no justification for this search.
Right.
Of
Assuming a warrant is required for this type of inquiry.
Well, Your Honor, we think it is. And we think it is based on case law,
What
third-party doctrine case
case
law. That's
law?
Carpenter. Thinking about cell phones, that's the
No.
Riley case. If you have a cell phone that gets taken at an arrest out of a car, a subsequent warrant to search the cell phone is required.
That's
So
not
we
the
think
same.
a warrant was required for these subsequent searches. And there was no warrant in this case. There's an expectation of privacy.
I struggle with, well, I struggle, to be frank, and where you're going to have to try to convince me, I guess, is
It's not going to work.
I struggle with the idea that DNA left at a crime scene, that there's any expectation of privacy by
Correct.
someone who leaves DNA at a crime scene, that DNA can't be, as you say, searched without a warrant to establish identity.
Well, Your Honor, I don't think any of us can go out of our houses without leaving DNA all over the place.
Not go to a crime scene.
The question of how something gets somewhere, that's the subject of the trial. I think the Carpenter case is really instructive for
You
the court
don't
here.
have a
And that
Fourth
case was
Amendment
about,
exception
it
of
was
privacy.
about third party with cell towers.
If it's your home, there's a reasonable exception of privacy. If it's not your home, there's not a reasonable expectation of privacy. And okay,
And there was a concurring opinion in
I'm
that,
just gonna stop.
that case.
The judge,
I think that's
don't go
instructive.
to a crime scene.
Um,
Don't cause a crime scene.
We leave DNA everywhere. If you carry a cell phone and it uses the towers, there
It
can be a
leaves-
trail of where you went.
It leaves your shit
I'm
everywhere.
sorry?
Don't we leave fingerprints everywhere?
We do leave fingerprints everywhere, but I would say, Your Honor, that things like your movements, cell towers, the contents of your cell phone, those are really personal
Content,
things.
ma'am.
That's how you carry out your
Ma'am, contents of your cell phone are completely different. Completely different than some of the. She's looping in things that you need a warrant for and things you don't need a warrant for. Things in your cell phone are different. So she's looping this into taking the argument that's known and trying to bridge the unknown and be like, we have an expectation of privacy in your cell phone. Yeah, especially if you put a passcode on it. You have an expectation that other people won't like get into your shit. But I don't, when we get into who else has access to your information, I don't think anyone has an expectation of privacy in things like what you share with social media apps if you access them on your phone, because you know that a third party is accessing them. These are growing and changing areas of law, but your expectation of privacy in your locked cell phone is not the same as your expectation of privacy if you walk into a grocery store and, you know, pick up a box of pasta, put it back down and leave, and somebody later comes and fingerprints it. It's just so different. Yes. Mom Unscripted said, Emily's been contacted by the FBI. Yeah. No. The FBI and I do not have a regular or frequent contact. Have we ever been in contact? Yes, but it's been a very long time, thankfully, because I rather just do this. Let's continue.
your business.
Look at the
That's how
judge's
you
body
go.
language.
You drive your car to go to the doctor, your cell phone's heading on those towers. DNA is even more personal than that. The tests
law
are so
may
different
change
than they
down the
used to be
road
now.
with her argument.
It can pick up all
It's
kinds
not
of
there now.
information. It takes very little DNA. DNA lives on surfaces a lot longer than fingerprints live on surfaces. So without more, they're not much of an indication of anything. There's a warrant requirement to protect people from unreasonable searches. And that's what we're asserting here.
He's like, stop while you're behind.
There's so much information contained in your DNA, and you can't stop from shedding.
I mean,
that when
but you
go
don't
out of
have a
your
reasonable
house. None of us
expectation of privacy of nobody like seeing you at a
to be able
Starbucks. Somebody could be
to
like, oh, I
have
saw them at a
that searched
Starbucks.
without a warrant could put anybody
out in
jeopardy.
public.
There's no privacy left. If that's going to be the standard, you put it.
Ma'am, have you looked at the internet? I know you're arguing there's no privacy left. You have privacy where there's a reasonable expectation of privacy. Your client doesn't have a reasonable expectation of privacy in things at the victim's home. There's no reasonable expectation of privacy there.
Put it in public so it can be searched. That can't be the standard. That would erode the Fourth Amendment.
No, ma'am. Okay.
Our position is that there is an expectation of privacy that society is willing to accept. Our position is that there's case law that supports this. Maybe not exactly directly on point,
Right.
but the court talked
Right.
about
Right.
one of the cases that we
Not
cited.
exactly
that's
on point.
Similar, it's out of Washington.
Exactly.
In that case, it keyed on whether the database was a
The court's like,
voluntary.
we've been doing this all damn
Law
day.
enforcement can search
We have
this.
9
or
other
not.
motions.
In this situation, that's not the case. You know from the exhibit you have and from the testimony that you heard that the FBI went into 2 databases that they weren't permitted to search. So if the court wants to go clear to that extreme, and the court shouldn't, the court should look at the Fourth Amendment. The court should look at expectation of privacy. The court should look at the 3 places there was a warrant required and it wasn't given. But if the court wants to go all the way down to whether or not there was a database searched where the people consented to have
Are
their
we going
DNA searched,
down
our case is
in
different.
an earlier round?
The FBI went into 2 other databases and searched those.
And they can.
There was nothing else happening until that happened.
They
And
were
it's
searching unknown
instructive,
DNA
I
against
think,
known
and
DNA.
important for the court to think about how secretive this all was. We are months from trial and we are learning things about how the government identified Bryan today in open court when we've asked for those things. There's a reason why there's so much secrecy.
Well, because
That's
it's
because there's a violation of privacy rights. That's why there's so much secrecy. Your Honor, this is an extremely important motion, and the court is going to decide whether we do have any expectation of privacy left or
the
not.
court's already
The
decided that, it
IGG
seems.
evidence in this case should absolutely be suppressed.
The judge's face is just like,
I suspect the state's going to raise an issue that you may need to respond to, but I'll let you respond to that if they do raise that issue.
I'll be prepared, Your Honor. Thank you.
Tricia said it's pretty catastrophic that they're learning new stuff. It depends on what the new stuff is
Thank
that
you,
they're
Your Honor.
learning
Or should I
and what it relates to.
permit evidence obtained potentially by searching databases that by its own policies, law enforcement said they wouldn't search?
That's another
So
question.
a couple points on that. First, even assuming that that's all correct and that they violated the
It
terms
seems to be the evidence.
the terms of service, Your Honor, don't affect the Fourth Amendment. The terms of service, and certainly Mr. Kohberger does not have standing to raise a violation.
That's a different issue. And the issue that they're getting into now is what happens when law enforcement is searching DNA databases that they said they wouldn't search and that don't allow for law enforcement access. And the court said that seems to be the evidence, which leads me to believe that the proprietary databases, the commercial databases that say you can opt in or opt out of your DNA being searched by law enforcement, the FBI's like, yeah, you can't stop us from searching a database, so we'll just do it. Like, your terms of service aren't our issue. However, it's not going to change the fact that the DNA was snipped by a crime lab from the crime scene, and then they took IGG DNA from Pennsylvania, and then they connected the two. You can loop out the rest of it, because from everything we've seen publicly, there was no match in any of those other databases. I'm interested to see what the state argues here, because maybe we'll learn a little bit more.
The terms of service. And even if he did, the remedy for the terms of service is not a violation of the Fourth Amendment. As we argued in our brief, the individuals, and as came out in testimony today, the individuals who are utilizing these databases, and we're talking about millions of them, are willingly sharing their information with each other, with millions of other people.
Isn't there a subset that says, but I don't want these people to look at it?
In some of the data,
The FBI, as I understand the evidence, then says, okay, we agree, we won't search those ones.
so I'll address that part, but on the database piece, the issue is that no one sharing this information with millions of other people could have a reasonable expectation of privacy. The test for that isn't, do they have a reasonable expectation of privacy against law enforcement? It's against the public writ large. So for example, we cited in our brief 3 different cases where Idaho's appellate courts have found people have given up a reasonable expectation of privacy in information that we share.
What's the takeaway here? if you put your DNA in a DNA database and say, I do not want law enforcement to access it, law enforcement has gone lol and will in fact access it. And those databases don't seem to be keeping that information necessarily private. So if you upload your data, then it will be searched. And part of the argument is, even if an individual in the public said that's a violation of my privacy, that's not Kohberger's privacy right. That's the individual's privacy right.
Shared with a single company, and it was shared with that company just so they could get the service from that company. Here, we're talking about people sharing it not just with the company, but with millions of other people, because sharing it is the purpose of providing it to the database. So regardless of what the FBI did or didn't do in terms of violating the terms of service, no one has a reasonable expectation.
Is it different if they share it with the company and it's obtained by lawful process from that company?
Does sharing it mean you lose your
versus,
expectation of privacy?
Going in the back window and taking it?
No, Your Honor, because right now what we're
Your Honor, excellent restraint in not saying going in the back door. Thank you. Thank you, Judge H. That was restrained.
asking is not reasonableness of the search. Right now, what we're asking is there even a reasonable expectation of privacy? And so the fact that no one has a reasonable expectation of privacy in those databases means that even if the FBI violated those terms of service, no one has a Fourth Amendment right to complain. And certainly Mr. Kohberger doesn't. He has not asserted factually or through evidence that
That's
he
the real
was
heart of the issue.
a customer to one of these databases. And
His-
maybe that
his
changes the
DNA
case if he
wasn't
were,
there.
but he's not. He's not even claiming that. He's not even asserting it.
Not his
Now,
right.
I do want to address the second part of the court's question about the FBI has indicated that they wouldn't do this. I believe that's a reference to the policy we've been discussing, the interim policy by the DOJ. I certainly do not speak for the Department of Justice. I do not work for the FBI. I'm speaking for the
Clearly.
state of Idaho, but I can read a document. And if you look at the policy in footnote 1, it clearly says this interim policy does not impose
This
any
would
legal
be
limitations on otherwise
such a
lawful
great
investigative or
law
prosecutorial
school
activities or
exam
techniques
question.
utilized by the Department of Justice, or limit the prerogatives, choices, or decisions available to or made by the department in its discretion.
This would be
In other words, their
A great
first
exam
problem is they're
question.
relying on a policy at all. The
A
US
vibrant
Supreme
class
Court has
discussion.
said policies do not equal Fourth Amendment violations. Their second problem is it's a circular argument. The policy doesn't say you cannot do any of these things. It's saying best case scenario, you're not going to do these
Well,
things.
if you were interpreting this as a matter of contract, wouldn't you have a problem? In the sense that on the one hand, it says don't do this, and on the other hand, you've got a more general sort of catch-all that says, but we're not really meaning anything we say.
No, I don't think there's a problem interpreting that at all. I think the problem is they are putting way too much weight on this policy as if it's somehow the law. And it's not. It's indicating, and we heard testimony today about best practices and what those mean. This is indicating best practices, but very clearly stating we are not limiting the Department of Justice to have to follow what's in this document as long as it's not limited by the law. And they're trying to use a violation of this policy or an alleged violation of this policy to say that they violated the law. It's circular reasoning. But despite all of that, the U.S. Supreme Court has said a policy violation isn't sufficient. Even the Department of Justice, as powerful as they are, they don't get to rewrite the Fourth Amendment by changing this policy. Now, I do want to address the defense is they're trying to pick and choose what they believe the searches are throughout this chain. And what they're leaving out repeatedly is where this DNA started. Where did the chain
Yeah,
start?
what are they leaving out?
Well, it started at a quadruple homicide at a crime scene. There is no case law
Right.
anywhere that the state could find, and the defense has not cited any to suggest that there is a reasonable expectation of privacy in DNA found at a crime scene. And I want to talk about the Davis case, Your Honor, because it actually cuts against the defense. Davis is the case where it was a very unique set of facts. There was an investigation into a shooting. An officer went to the hospital, and when he went into the victim's room, he saw a bag of clothing. He seized that clothing under the plain view exception to the warrant requirement. So the clothing wasn't abandoned. This was an exception to the warrant requirement. Later on, this individual who was a victim now becomes a suspect, and they have this DNA and they test it. And the Fourth Circuit said, no, you can't do that. You can't take it because he's a victim and then later use it against him as a suspect. That is nothing at all like what we have here. And in fact, if this court looks at the district court opinion that was affirmed by the Fourth Circuit, it expressly states nothing about this holding is indicating that the government needs to get a search warrant for crime scene DNA.
Right.
That does not support their position.
Right.
The Achilles heel in their entire chain argument here is that there is no case anywhere that suggests that a DNA analysis restores a reasonable expectation of privacy. So in the Davis case, no one lost their reasonable expectation of privacy. It was seized pursuant to the Plainview Doctrine. The other case that they're relying on is that recent Supreme Court decision from Arizona. They attached it to their reply.
What Arizona
That case is similar to Davis in that the DNA was collected from someone who consented to it under a statutory framework because they had to provide 2 vials of blood so it could be tested for alcohol and drugs. Again,
So
that
DUI
case would have
context.
come out differently had the 2 vials of blood been found at a quadruple homicide.
Right.
That is a pretty big factor in deciding whether or not
Well, the
someone
case
has a
law is
reasonable
pretty settled with
expectation of
regard to
privacy.
searching a person that's a suspect. If most states, and I say most because I don't know if it's all, but most states, if you are going to have a blood draw at the hospital in the investigation of a DUI or what have you, they can't just take your blood. They need a search warrant to search literally your body for your blood and then extract it. That is common most places. Check where you live, know your rights there, but that's not uncommon. That's entirely different than searching a crime scene to investigate and solve a crime. That is searching a person to prove that they committed a crime, which is a massive distinction because the crime scene you don't need a warrant for. Just nope.
In Idaho, while this specific issue has not been addressed by the appellate courts have told us what to look for when you're talking about a reasonable expectation of privacy. And it's things like ownership, possession, control, ability to regulate access.
Yeah, there's standards for all of those.
Mr. Kohberger had none of those things with respect to the DNA on the knife sheath. We are talking about not just a crime scene, not just a murder scene. We're talking about a murder scene in a house to which he has asserted no connection whatsoever. 4 victims to which he has asserted no connection whatsoever. We're not just talking about his DNA happened to be found in, a dresser drawer or something. It was found on a knife sheath where 4 people were killed by a knife. This is as crime scene as it gets. And that's where the DNA was found. And they can't cite any case law whatsoever.
Your Honor,
and
it's
so
very
they try and just ignore that and skip
at the
over it
crime
and say,
scene.
well, let's just talk about the DNA analysis.
No, they can't because of where it's
The other
found.
problem they have, as this court questions indicated, is the analysis that was done in this case, as we heard the evidence today, is not something that revealed a bunch of private medical information. In fact, the defense's own expert, who is engaged in the same kinds of conduct as Othram in terms of developing these SNP profiles,
What did their
said he had
expert say?
successfully developed hundreds of SNP profiles and never once learned medical information about any of those individuals. He testified that he has never even heard of a forensic investigative genetic genealogy case that was solved using medical information. And in fact, and I wrote this down when I asked him what he would need to do to learn medical information from those SNPs, he said, quote, "It would be a lot of research." So the defense is positing this question of, they're saying the court needs to ask itself, what could law enforcement do with the DNA? And then decide whether or not there's a violation of the Fourth Amendment. But that's not what the U.S. Supreme Court says. In Maryland v. King, they
We
were
don't
very
live
clear
in
when it comes
the
to
Minority
DNA,
Report movie
because
just
the
yet.
defense there was asserting the same argument. We
Right.
have DNA. DNA can reveal a bunch of private medical information. And the U.S. Supreme Court said, quote, "Even if non-coding alleles could provide some information, they are not, in fact, tested for that end." So the question under the Fourth Amendment is not what could law enforcement possibly do with this? The question is, what did they do? And in this case, there is no evidence whatsoever that they did anything to find out medical information about Mr. Kohberger. It was all related to ancestry and identity. And as the U.S. Supreme Court said in King, there is no greater privacy interest in DNA than in fingerprints, so long as law enforcement is limiting its activities to identification. And that's what we have in this case, is identification.
Right.
Now, the other problem that Mr. Kohberger has here is, in my view, at least, he's been a little bit wishy-washy on the DNA on the knife sheath itself.
Okay. Wishy-washy.
You don't get to claim Fourth Amendment standing and then just say, well, that may be my DNA, but I have no idea how it got there.
This is a fair point, because the argument is, how can you say it's standing if you're saying it's not yours? Like, if it's not yours, you don't have standing. But if you say, hey, that knife sheath is mine, well, hey, why is it, partially under one of the victims at the scene of a quadruple homicide then? Because I have questions. So the wishy-washy is the defense being stuck with we'd really like this suppressed, but we'd really like to also say it's not ours. And you can't do both.
And the Idaho Court of Appeals has held in a couple different cases that if someone, for example, in one of the cases denied the existence of a bag that had been thrown out of the window, and the court said, well, you can't have a reasonable expectation of privacy in a bag that you deny exists. This is a very similar thing. We have a defendant who is trying to get the best of both worlds. He's trying to say, well, it's not my DNA and the state can't prove that, but he's also trying to say that he has Fourth Amendment standing. And I
can't have your cake and eat it too.
That is not how the Fourth Amendment works.
Which I don't like that phrase, actually, because I want both
Your Honor,
the
I
cake
also
and
wanted to
eat it,
respond
but
to an argument that was made in the reply brief, since I didn't get a chance to do it
wishy-washy.
in the
We'll just go with
briefing.
wishy-washy.
And this has to do with the trash pull in Pennsylvania. And I'll just start by saying that the defense has offered no evidence whatsoever that would take the trash pull in this case outside of the Idaho Supreme Court's decisions in Donato and
We need
Paluzzi.
more information about the
Paluzzi
facts
is
of the
very
trash
recent,
pull.
came out in the middle of the briefing, in fact, and rejected the exact arguments that are being pressed by the defense
Exactly,
here.
Michelle.
Obviously, this court
There's
is
no
bound
point
by
in having
that
cake
reasoning.
and not eating it. Exactly.
When the state pointed that out in their response brief, in the reply, the defense made an assertion that this case is different because the documents the state has provided are not clear on where the garbage cans were located, and that maybe the officers went up onto the driveway instead of collecting them from the street. Correct. I'm sorry, Your Honor, I misspoke. The trash company collected them on behalf of the officers.
They just did the regular pickup, I thought. And
Correct.
pulled over after they got out of the neighborhood and said, here's what we got.
Well, I do believe it was prearranged with the FBI for them to do that. But my point is just,
That's new information. Let's pause that right there. Did we catch what the state just said? It seems to me at this point that the state is not talking about case law, but talking about the facts in this case, that the FBI arranged with the trash company to go pick up the trash from the house, and then the FBI got it from the trash company. The trash company's allowed to go get your trash and pick it up, and the FBI can take it from them. The FBI can't go marching their happy asses down your driveway, open up your trash can, and take shit out of it. The FBI can say to your trash company, hey, when are you doing pickup at this house? Would you mind doing pickup at this house with like a fresh truck that has nothing else in it so that we can collect some stuff from you? Sure, that would be great. That is a completely different circumstance. When we talk about some of the hearings going on in the Corey Richins case today, we'll talk about whether or not there was a search warrant for her car. Law enforcement said to her, hey, can you grab us your phone? They had a search warrant for her person and for her phone, which means they can take her phone from her, but she left her phone in the car. They couldn't search the car yet. They said, hey, can you go get your phone for us? And she said, sure, and handed them her phone. If law enforcement asks you to go get anything out of your car, I'm going to need you to say, do you have a warrant for that? But she was just like, hey, go ahead. So that is the fact scenario that we are against now, with The FBI did not take the trash company did, and you don't have a reasonable expectation of privacy from the trash company not picking up your trash. The FBI knows how this game works, and they're not going to get yeeted on a technicality because they're taking your trash can from where they're not allowed to take it from. The case law on that is incredibly well settled, and there is a ton of case law about whether you can search, where you can search in the house, what kind of devices you can use to search in a house. Can you fly a drone over the house to search a backyard? Is a drone plain view? Is it not plain view? Can you use light that perceives heat through a wall to see if somebody has like a grow operation because the house is putting off too much heat? Can you go look at somebody's electric meter to decide if they're using more electricity and maybe up to cooking in their home, not of the dinner variety, all of that kind of stuff. So there's a lot of case law. So it's interesting that now we know that the FBI took the trash from the trash company took the trash from the house.
I do think it's telling.
I know a
that
lot
they
about
didn't
grow
provide the
operations.
court with these documents.
I spent a lot of time prosecuting cases in California. And there's a lot of case law about grow operations in California. Shockingly. You know how I feel about it? If you can grow it and not blow shit up, I'm not mad about it. Maybe at some point everyone will catch up and just be like, well, if you can grow it, why is it a problem? Just let it be legal. Maybe everybody would be happier. But anyway, growing weed's easier than like distilling your own wine or microbrewing shit. Just let it go.
That they believe are not clear. And I looked them up to make sure that they were. And in fact, there is an FBI report that was disclosed in discovery that details that the garbage cans were at the end of the driveway, at the end of the property. And at the end, it says, see video. And there was a video disclosed in discovery where you can see the officer's body cam as he drives by the house shortly before they look in the garbage cans. And they're in the exact place you would expect garbage cans to be when they're out for collection.
And when your garbage is out for collection, law enforcement can come take it. They can do that if it is out for collection.
They, of course,
Lindsay,
have the
you make a
burden of
good point.
establishing a search. They haven't presented any evidence to that. It's not sufficient for them to stand up here and say, well, it's just not clear. Which brings me to my final point, and that is Ms. Taylor continues to say there was a lot of secretive stuff happening in this case.
Super secret.
That
She
is
said
not
super
sufficient to satisfy their burden that there was a search, that someone had a reasonable expectation of privacy. When you have the burden, you have to present evidence. You don't get to just stand up and say, well, it was very secretive. I will note in this case, as the court may be familiar with it, as it's probably read back through the record, the defense in this case has gotten a lot more information than many defendants in other states who have, where there's been an IGG investigation, because the majority of courts have found this isn't really relevant information. It's just a tip. Now it is what it is in this case, and we of course complied with all the court's orders.
Thank
and
you,
provided
counsel.
the information, but there's not a lot of information, not because it's secretive, but because it's just not our case. It's not what we're focused on. It's not the evidence we plan on using at trial. And yes,
Early
IGG was used in this case. And yes,
preliminary
it did point to
investigation.
the defendant. But the fact that that happened doesn't mean that there was a violation of the Fourth Amendment. Unless the court has any questions, we ask you to deny the motion to suppress.
If the FBI, in fact, violated the Fourth Amendment rights of Mr. Kohberger, you would agree the state is burdened by that?
The state would be burdened by that.
That's a great way of putting it, Your Honor. Yes, the state would be burdened by that. Yes.
The state would be more than burdened by that. The state is not, and I think what the court is getting at that with that is that just because it's a federal law enforcement agency that's helping investigate, if the federal law enforcement agency does something, it doesn't mean that the state of Idaho prosecutor's office is like, but the feds did it. It's not really us. The feds were helping investigate this case. If the feds violate something, then yes, That becomes a problem for the prosecution team because the feds were part of the investigation team. So if there was a federal issue with law enforcement, then yes, it becomes an issue for the prosecution. Also, the reason it's easier for him to argue is that all the case law is on his side. It's very easy to make an argument when all of the case law is literally on your side. So Sue said, would that matter? If the FBI violated the Fourth Amendment in the investigation, yes, it would matter, because then you would have issues where suppression would or could need to happen. Doesn't seem to be what's happening here. But we'll see.
I'll start backwards. I
Great.
will answer the court's question that the court posed to Mr. Nye. The state is burdened by what the FBI did here. Every action the FBI took in here, all of the secret actions that they took, show you that there is an expectation of privacy that society is willing to accept.
I don't think that's
They
why it's
didn't want
secret.
anybody to know what they're doing.
It's their investigative techniques.
It
They're
is
allowed to do that.
interesting to hear that discovery requests and motions to compel and orders have been complied with when I've learned at least 3 new things in the course of preparing for this hearing and being at this hearing.
Which is
so far
frustrating.
today. That's a surprise to me. So I wanted to say that, and I want to go back to the trash pool. And I want you to know, when you consider this, that that particular area had an ordinance that trash had.
Supreme Court reject that argument very recently.
Your Honor, they might have, but
There was an ordinance. The courts rejected that argument. Okay. Oh. We backed up a minute.
I want you to know, when you consider this, that that particular area had an ordinance that trash had.
Supreme Court reject that argument very recently.
Your Honor, they might have, but that ordinance isn't all. I was starting with the ordinance, that it has to be collected by a trash collector, that a certain trash collector, and that you have to put your trash out too. In that circumstance, the FBI worked with the trash collector and had them go just to get that trash and then take that trash somewhere else too. And those are some extra actions that the FBI took in this particular case that changed them.
How does that change the analysis?
Well, Your Honor, I think that it changes
The
the,
expectation of privacy is lost when you put it in the trash can to be taken away, per the Supreme Court's opinion, even if it's a well-regulated neighborhood by ordinance that says when and where you have to put your trash.
Right. Your HOA
well,
is like
Your
trash
Honor,
days
I think
Friday,
that
sure.
there is an expectation of privacy when you have to comply, you have to put your trash out in that particular manner.
That case.
I
Unless you're saying the Supreme Court was wrong, the Idaho Supreme Court was wrong, and you're reserving that for a later higher appellate court, that's fine.
Your Honor, I may not always agree with the Idaho Supreme Court on everything,
But I have to follow what they say.
but I have to make a record when I don't,
My kiddo's taken off for
I'm just trying
practice.
to make sure we're talking about the same thing.
and I have to distinguish the case as best I can.
All right, buddy.
As well.
See you.
And I think it is different when you have the FBI telling the trash man what to do. I'll move on to something else. I want to talk about now where
move
Mr.
on.
Nye started. That's
Yes, ma'am.
Department of
Yes, ma'am.
Justice
Time
interim
to move on.
policy, and he read you the first footnote. And I would just direct the court to pages 6 and 7 in that. And that is that the FBI is not to search databases that they're
That
not
was my
allowed to.
oldest, for
In
those
this
of you in the
case,
chat.
2 of
who
the
were
4
asking.
that they did. And the next page talks about the things that have to be kept in case there's a prosecution case. The prosecutor talked to you about, well, this is a tip. This is just a tip. It's like an informant.
Oh,
And
dear.
It's thought of.
Are we
in
gonna
this
fight over
Department of
what just
Justice
the tip
policy
is?
as more if they're told to keep things in case there's a prosecution case. And so that should be considered when you're considering the entire picture that we have here in light of the amount of secrecy that happened here. That takes it out of being a tip. It takes it out of being a lead in the case.
I am not
I would remind
mature
the
enough
court
for
and
this
should the
argument
court-
today. I'm not pausing because I'm not mature enough for this argument today. But I am pausing because there was an excellent question in the chat that I wanted to answer. Emma said, wasn't the trash collected in a state that isn't Idaho? Yes, but when we are dealing with multi-jurisdictional cases, the Constitution still has to be followed. So if law enforcement in that state does something that violates either the laws of that state, the Fourth Amendment, then glossing over the fact that there can be litigation over what law applies to the action that were taken, depending on the investigation and what agency it is, we're going to move past all of that and go broader strokes. But the rules still have to be followed in that state. So it's not just because, hey, we grabbed it in Pennsylvania, this case is in Idaho, we can't ever litigate whether what was done in Pennsylvania is right or wrong. We still have the Fourth Amendment rights to the defendant, and whether or not something that was done in another state might violate those rights is still something that they can litigate in Idaho. And then sometimes you have jurisdictional issues over which law might apply. The Fourth Amendment's going to apply everywhere because Constitution. So that is why what they're talking about happening in Pennsylvania matters here, because it was part of that investigation. Look, it is a large country where people can go state to state, and you can't have law enforcement saying, hey, well, if you get over state lines, anything we did in that other state doesn't matter, so we can just do whatever we want, because that would not be okay. So with that is why. But yes, the issue with regard to the trash pull or the taking of the trash is from Pennsylvania. So let us continue.
Knows pretty well when we're talking about confidential informants and that type of law, you have to have some reliability. And there should be a big question here about how reliable this is, how reliable whatever it was the FBI did
the trash
to develop this profile with the rest of the secret things that they did in this case, and their willingness to violate their own policy. Certainly not suggesting that this court create a new Fourth Amendment right based on violation of Department of Justice
disinclined
policy,
to do that.
but I'm saying you should look at that and consider that when you're thinking about what the FBI did here and how credible this informant was, how credible this lead was in this particular case. That's fair for you to consider, just like you would in any other confidential informant type of case.
She's talking about the IGG
I would like to
company. No, the DNA company.
Distinguish what we have
the
here
database company.
with our subsequent search. I talked a lot about that before. I won't go too far on that. This is a second search and a third search if we're just focusing on the two SNP files. These are extra searches that happen after the initial search is done and the STR profiles developed, and it goes into the CODIS database. This is completely different, and a SNP is different. You heard a lot of testimony about how this is sort of new and evolving technology, and the standards that apply are catching up, and there's best practices. You heard a lot about that today. So I don't think we can just say, well, if CODIS is fine, this is fine.
Oh yes, it's not lost on me, RJ.
There is a ton of information. It's your whole genome that gets profiled. Maybe the SNP that uploads into MyHeritage, which it shouldn't have, maybe that SNP doesn't tell you certain things about a health profile, but the potentiality is there in the SNP profile. For $12, you can upload that profile and find out all kinds of personal health information. It's the potentiality of that. And that's the Carpenter case that talked about the potentiality of that.
So
people have an absolute privacy interest in their health matters. Idaho has a couple of different laws on the books. It has the family DNA law on the books. And think about HIPAA. I mean, we all have to sign those forms every time we go to the doctor.
This is not even close to that issue.
Health matters are important. If you can upload one of these profiles for $12 and find out all kinds of information.
Wait, where can you do it for $12,
How is that not a Fourth Amendment issue?
Because it's not your client that did it.
That's what that SNP profile can do. And that was done twice without a warrant in this case. And there should have been a warrant.
It wasn't.
It violates Fourth Amendment rights, Article 1, Section 17 rights, and this must be suppressed.
She's in a hard spot because if she's talking about the DNA taken from the crime scene, the DNA taken from the crime scene at the time was unknown DNA. And she's arguing, look, there's all these privacy rights in that unknown DNA, but she also can't argue my client has a privacy right in that unknown DNA without saying my client's DNA was there. The court didn't ask any further question because the court is just not persuaded. She bears the burden in this motion to argue that the investigative DNA should be suppressed, which should suppress everything else. This is a losing battle for her, but it is a battle that must be fought. And maybe down the road, the law will change and these arguments will be preserved. And her client will come back on appeal 15 years from now saying, see, my attorney argued that there is a privacy right in this. That argument's been preserved for appeal, and therefore we can bring that up again years from now. So some of this is not winning at the moment, but maybe down the road, this becomes crucial to overturning her client's conviction if he is convicted. So this is a losing battle at the time. But again, Ann Taylor's like, we're going to look into the future and argue everything we can argue because that is her job. At the moment, it's losing, but laws change and the courts change. And this is emerging technology, and that is an area where the law changes more quickly. The
All right,
crime
that matter
scene
will be
is not
taken
emergent.
Under advisement. Let's proceed with the Frank's argument on the IGG and the Frank's proffer more generally. Or did I get it wrong again?
I'm prepared to do that. I would request that the court maybe give me 5 minutes. I have
All right.
different things.
We'll take 5.
Thank you.
Back in
Take 5. So the court's on a break. We're going to zoom past the break. What Ann Taylor is saying is that she needs a minute to collect her arguments on the Franks hearing, which is regarding the underlying search warrant and whether there is an issue with the underlying search warrant. Did the law enforcement officer make improper statements that weren't true, or were there substantial omissions to the affidavit? So this is going to the statements regarding the search warrant affidavits. We're going to zoom past that court break. I love having zoom room, and that's where we're at. Back on the record. Let's go to the Franks hearing.
All right, let's take up Frank's.
Your Honor, I think on the court's bench, there was a document placed, so
What?
it had initials to
Oh,
comply
thank you.
with the court's.
Appreciate it.
All right. Your Honor, the purpose we're here for today is to offer you a preliminary showing of why we should have a Franks hearing.
So
To do that,
they have not yet had a Franks hearing. This is trying to meet that foundational element of whether or not there will be an evidentiary hearing with witnesses. For those of you that have followed my coverage with the Karen Reed case, we saw this with a hearing about whether you're going to have a hearing. Any of you that work in a corporate environment know about a meeting, to set a schedule for a meeting and then set an agenda for a meeting, then finally have the meeting. Will the court grant a hearing with witnesses regarding Franks or not? The Franks hearing will bring in the witness that made the affidavit to question the witness about whether things were omitted from a search warrant affidavit and whether or not that affidavit should be yeeted or parts of it should be yeeted, or whether the entire search warrant is invalid and gets thrown out. So this goes to the search warrant affidavits, and she's arguing that there should be an evidentiary hearing. The state is going to argue that there shouldn't be. So this is argument for a Franks hearing.
we will show you that in this circumstance, the affidavits that supported search warrants in this case had false information in them that was intentionally placed there. There was intentional omissions of information that are material and exculpatory to Mr. Kohberger. And without the false statements and with the added information in, probable cause on the warrants should not be found. Today, I'm asking you to listen to what we have to say, look at the exhibits that have been admitted, and I'll walk through those with you to talk about the 13 areas. And at the end of this hearing, we will have met the preliminary showing required in order to schedule a Franks hearing and fully challenge this.
With the exception of the IGG, which I think we've already heard the evidence on. So
We did hear the evidence, Your Honor, and I will not repeat that evidence. I'll argue from that today.
my only point being that's not in the preliminary stage that all the other issues are on.
Okay. Well, I'll try to hit that as hard as I can.
So it's a 1-2
Your Honor,
on the hearing.
in this
meeting the
case,
threshold to
there
have the
were a
hearing
lot of search
first.
warrants. I'm going to draw the court's attention to those beginning on December 23rd.
I want to hear a
That
lot
day
more about
is
this.
important because it was just a few days prior to that for the first time ever, Bryan Kohberger's name came up in the course of this investigation. Your Honor wouldn't know that by reading the affidavits for probable cause. Nobody would know that. That's because that information is omitted from the affidavit. That information is something that you heard about this morning in testimony, that but for the FBI's work going into databases they shouldn't have been going into, violating their own policy, keeping no records, and doing this all behind the scenes in secret. That's the only way a name was produced. Prior to that time, the lead detective in the case had not heard the name Bryan Kohberger. He had not crossed their radar. That's nowhere in the affidavit, and that's important because that's intentionally withheld from the affidavit because of the work the FBI did, because the FBI went behind the scenes and did things that they shouldn't have been doing, because they searched databases that they shouldn't have been doing. We don't know what else they did wrong because everything else is a secret. We don't know what else they did wrong because there's no record kept. There's no process kept. We can't rebuild the process that they did to identify Mr. Kohberger. We can't do any of that because they kept no records, produced no records, and did this all behind closed doors, and it was withheld from the magistrate. Had the judge heard about that, signing
It would
probable
have
cause,
changed nothing.
that would have been really important to understand. We don't know this name. We heard it for the first time now, and we only know it because we violated our own policy to find that. That may have given the judge caution. It may have made the judge wonder what else are they doing behind the scenes. But that was withheld from the judge. That judge
Unlikely.
never got to know that. Let's talk about what the judge did get to know with that in mind, and that's a really important backdrop. These affidavits are a group effort. I think the court's heard a little bit about that. And if the court has some of the initial
I hate a group
exhibits,
project, I'm not going to
the
lie.
court will know, and I'm at D2. The court will know
But
that this
what
was a
evidence
group
do they
effort.
have once
The
they identified a
FBI,
suspect to tie
same
him to the
FBI
location?
that went behind and violated their own policy to try to identify somebody. They were co-located with Moscow Police Department and working on these affidavits to present to the judge. The first warrant that gets anything related to Mr. Kohberger is, I refer to it as AT&T 1. It's on 12/23/22, and it's for 48 hours worth of records of Mr. Kohberger. And I want to go through that warrant with the court having in mind that the IGG was purposefully and intentionally withheld from the magistrate. And I want to talk about some of the other problems.
This is all going to
with
be
that
about the
warrant.
IGG. And I went through most of these motions. All of them really hinge on the IGG argument.
This probable cause affidavit talks about an interview they had where the person that was interviewed said that she heard things and saw things within her house. But what is written in the probable cause affidavit is seriously lacking in detail. It's wrong and it's false in many places.
Lacking in detail, wrong and false.
The way the affidavit reads, it says this person stated she went to sleep on the second floor.
This is
She
the
was
roommate.
awoken at 4 by what she stated sounded like one of the victims playing with the dog, which was on the 3rd floor. A short time later, she thought she heard one of the victims say something. That caveat, she thought she heard, is a problem. That's not at all what was said. This person was interviewed shortly after 911 was called in the afternoon of November 13th, 2022. And she was sure, I'm at Defendant's Exhibit 8A, page 281, lines 4 through 10, when this witness was sure that she heard this particular victim go down the stairs, go up the stairs, and then come running back down the stairs. That is not what's contained in this affidavit at all.
I'm going to back up what the witness said she heard, because this is information that we do not yet know about this case. And so I'm going to back up her retelling of what the roommate said in the interview.
When this witness was sure that she heard this particular victim go down the stairs, go up the stairs, and then come running back down the stairs. That is not what's contained in this affidavit at all. That
Are
is
there multiple
repeated
interviews?
during this same interview a couple of different times at page 287. It's also repeated in a subsequent interview that same day. This is Defendant's Exhibit 8B. That's at page 313.
For those of you in the chat saying, oh, I haven't heard this, this has not been publicly available until we're hearing this in this hearing. This is contemporaneous now. They are doing this hearing now. And so this is new information. We don't know what the state's going to say. Most of this information is not in the public eye. So we will see what the state responds with. But they are saying what was said in the interview is not what was in the probable cause affidavit for the search warrants.
And again at
From the roommate.
320. I've got one more of these.
And the
where
judge
this
will
is
have had all
repeated.
of this. This is sealed. The judge would have had all of this information previously and these transcripts. So the judge has heard this. This is not new to him. Foo
It's
File said, what
repeated
does this have to
again
do
in
with Bryan Kohberger?
in
It's his hearing about his evidence
D8C as
in his
well.
case. And
That
the
is
search warrants in his
important
case.
because that's misleading to the judge. That waters down what was said. And that matters in the probable cause affidavit because the officers, when they wrote this, knew that wasn't the case. They knew this particular person that DM said was upright and running down the stairs, that's not what happened. That person was killed in the bed and never left the bed. And so the officers water that down because they know that fact is wrong, but they don't tell the magistrate that. They also don't tell the magistrate that this witness has claimed memory problems, that this witness has claimed that she's not sure what she heard or saw was real or whether it was at a dream, and that is contained in Defendant's 8C, and that's going to be beginning at page 396, 398,
I imagine there's more
399,
to that information
403.
there.
There's further statements from
Regarding
that
trauma.
witness in that police interview that said that she had had too much to drink and couldn't remember. None of that is given to the magistrate. That is information that's withheld. That's credibility of the person telling law enforcement these things. And the magistrate had a right to know that whatever is laid out in here isn't exactly the way it was. That person had credibility issues, and she said things that were just absolutely untrue and couldn't have been true. Law enforcement knew that. That was intentionally withheld from the magistrate. That matters when we're talking about credibility and sets this whole thing into motion. Your Honor, the next part of the affidavit
I'm
talks
interested to
about
hear more
what they have
about
determined
that.
to be suspect vehicle number one. And it trails a path of pieced together cameras. But what they don't tell the magistrate is that the camera near the residence, the 1112 King Road camera near 1122 King Road, you can't tell what kind of car it is. They don't tell the magistrate that that's an impossible car, that their expert can't make an identification off that. They don't tell the magistrate that this is pieced together from various other videos throughout the area. That's withheld from the magistrate. That's important information when you tell a magistrate, we found this car doing this thing and we know what it is. It's around this particular area. The next issue is the year of the car. Law enforcement works with the FBI to determine the year of the car, and the FBI provides some possibilities after numerous submissions to them, and the court knows this and can read about this. This is going to be in D10. That's in D9. And finally, after several submissions, that's when the FBI IML says, I can make a car identification. The issue with that that's not disclosed to the magistrate is that car appears one time on one video and not any of the others that they try to say are the path. It's not, let me see if I can say this right. It's not following a consistent trail where the one camera that can identify the car where it appears again. It appears one time, and then what law enforcement did was they took several videos from all over the area and said, well, it's the same car, and we have an identification. That's not all. The identification was most comfortably from that FBI agent to be a 2011 to 2013 Elantra. And that's what law enforcement relied on. The court has, it is D12, and it's the Be on the Lookout that was issued by Moscow Police Department, where they look for a 2011 to 13 Hyundai Elantra. And that's what they're looking for. And they don't tell the magistrate that's what they're looking for. They mislead the magistrate and let the
A lot of you are
magistrate
asking
believe-
about why she's talking about the magistrate. The magistrate is who signed the search warrant at the beginning of this. So these search warrant affidavits were submitted to the magistrate. She is saying that the judge needs to have a hearing because her argument is that the magistrate was not given all of the information, that law enforcement kept information out of the search warrant affidavit that would have been critical, and therefore there should be a hearing to determine whether all of the search warrants based on that affidavit should be suppressed. And she's saying this is why. If there are misrepresentations, lies, omissions in search warrants, it can be critical and it can cause the entire thing to get suppressed and everything you search from it to get suppressed. We're going to see what the state argues. A lot of what we've heard in this case today is arguments. All the motions underlying this, or most of the motions underlying this, are sealed. So we don't have a full basis of information because a lot of it is sealed. So we will see what the state argues. But the reason she's talking about magistrate is because she is talking about who the search warrant was submitted to. Different jurisdictions break up the level of judges differently and have different judges sitting in different assignments. So that's why she's talking about the magistrate. The magistrate is a judge, just a different level of the judge.
Believe that they have a clear view of this car making this loop, and that's just not what happened. It's pieced together and it doesn't make a whole lot of sense.
Oh, her job is to try to get every
Law
bit of
enforcement in their affidavits talked
evidence
about
suppressed. That is her
this
job.
dog barking, and they key some time and they say this is when something was happening inside this house. We can hear this dog barking, and they use the videotape to get a time off that, the surveillance tape from the neighborhood, the 1112 King. And so they've got this time, but they also have this video, this trail that they've picked out a time that something probably happened here. And they don't tell the magistrate that this dog that's barking continues on long after the car they're interested in has left the area and then abruptly stops. Your Honor, the dog was found the next day inside the house in a bedroom with an open door, where the other bedrooms that contained people that died, their bedroom doors were open, and this dog had not tracked any blood around. The dog had no blood on it whatsoever, but it was just sitting in an open room a day later. The magistrate is not informed about that either. Then the police department goes through maneuvers to tell the magistrate that they did this investigation. They talk about a traffic stop,
Interesting.
2 traffic stops actually.
The information about the dog is really interesting.
There's no connector in there. This is where the lack of the IGG becomes really important. If you know about the IGG, you know why that would be built. Otherwise, 2 random traffic stops months ago in pretty populated areas with a lot of college kids really doesn't add up to be an investigation. But those are put in there to try to bolster up this investigation and say it was something that it wasn't. Probably the worst part of that is relying on after the BOLO went out for 2011 to 13 Elantra,
Bolo means be
then
on the lookout.
WSU, Washington State University
Literally,
officers
B-O, out loud.
find cars. They find one that's registered to Bryan Kohberger, parked at the apartments he lived in, but it was a 2015 Elantra, and so they don't really do much with it. But this is placed, that is placed in the affidavit like it was an investigative fact, and it wasn't. It was on the 20th of December when the lead detective, got a hold of WSU police and found out about that and said, oh, hey, you called this in. He didn't know about that before, but there's no context around that. That's just stacked in there like it creates probable cause when it doesn't. You know that's the case when you look at a couple of our exhibits. One is prior testimony from that same detective. And if you look at the messaging between the detective and the WSU police officer about the timing of that. So it's based on this false investigation trail, and it's based on statements that are completely out of context from somebody that they interviewed that are incorrect statements when you take the totality of the circumstances together, and statements that this person disclaimed a couple of days later because she wasn't sure what she remembered was real, and give that to the judge. If you add in the missing piece of IGG and what happened with that, and as a judge, you know you've got law enforcement willing to violate their own policy, and you know that you're not being told the full story about what a witness is saying, and you're being led down this path to say there's a real investigation when there wasn't a real investigation, you don't find probable cause on that.
If I find that the IGG was not unconstitutionally obtained,
Because it's not.
doesn't it just add to the probable cause?
No.
If it were to have been disclosed, it would have simply created more basis to suspect Kohberger.
Your Honor, if it had been disclosed, think about how that would read.
His DNA was there?
We used a process to make an identification. This is a new technology. This is called investigative genetic genealogy, and we identified somebody. We did not keep any of our documentation because even though Department of Justice policy says we need to, we decided not to. Even though it says we can't go into certain databases, we really wanted to figure out who this was, so we just ignored that policy altogether. I don't know how a judge could find that credible. You don't even know how that happened. there is a great big question mark about how that happened. To Your Honor's point, you should find it unconstitutional. If you
He's not gonna
don't
do
find it unconstitutional, it's a separate analysis. I appreciated being able to talk to the witness about that today, but it's a completely separate analysis. You're looking at integrity. You're looking at what a court can rely on to sign off on an affidavit or a search warrant. If an affidavit is presented to a judge and you know that the rules don't matter, that terms of use of a database don't matter, and that you're going to hide what you do, and that doesn't matter either, there's not a lot to rely on. If law enforcement came to the magistrate and said, we want to go search this house over here, and they said, we really think there's going to be evidence of a crime in there because we've got this confidential informant, and this confidential informant has provided a lead, but we need to tell you that we don't have real reason to trust this confidential informant because they won't tell us how they know that. They gave us a picture, but they won't tell us where they got it from or when they got it or what means they used. They threw away their camera. They threw away all the metadata. They won't tell us anything about that.
I don't think they have
And
to.
by the way, the confidential informant maybe has some integrity issues. A judge is not going to sign off on that. And then if you say, but to support that, I built this false look at a whole investigation here. I'm going to tell you these other things that I know that I had no idea about before my confidential informant was here. And these things don't add up anyway. There is not, in my view, a judge that's going to find probable cause because somebody got stopped by law enforcement. I think it was a seatbelt ticket months before.
The purpose of the submission of that was simply to identify the car that he drove and the fact it didn't have a license plate on the front. It wasn't to suggest it's otherwise connected to the homicide, except to say this is a car of interest and the defendant was found driving it.
Right.
Well, let's talk about that license plate for a second, though, because that's not something you can see from the videos. And that was testimony you heard today. You can't see that from the video that the cops relied on here. So that bit about the license plate, that's something a little bit extra that happened after we have this IGG stuff. That wasn't known before. There was no video collected from WSU before. There was no communication with the officers at WSU before. So
Well,
if
because they didn't have a suspect.
before the identification through IGG,
I'm just not tracking why that matters. Go ahead.
it matters.
Why would they start asking
because
WSU when they don't have a
this wasn't a real investigation. These are things that are put in there to make it look like an investigation happened, to say, don't look here at this big glaring thing that's missing, this whole piece about why we identified him. Don't look here. We don't want you to look here because this is ugly, this is dirty, and this isn't real. That's precisely why those things are placed in that
it's
PC
DNA though.
affidavit like that. So based on that, the first warrant gets issued. It doesn't end there. This warrant is not good. There's too much missing information, false information, and information withheld from the magistrate here. But then the warrants just rely on one another. There are other things to add into later warrants as well. And so I want to go through some of those other things with you.
So it seems that there's a lot of confusion in the chat. Don't worry, chat. I've got you. Okay. On a broad summary, the difficulty with what she is arguing right now is that they are making arguments based on sealed filings. So I can't go through the filing with you and say, this is exactly her argument, because all of those filings a lot of those filings are sealed. In the filings we have gone over, she is arguing in multiple different cases that the search warrants should be thrown out, which means anything you take from the search warrant gets thrown out because the affidavit that the search warrant is based on is not good because. The because is what she's arguing now. Your Honor, the magistrate judge would not have found probable cause if law enforcement had included the information they didn't include, had they not misled the magistrate, and had they not excluded exculpatory information, and had they not included inaccurate information. That is her argument. Does that mean that there was inaccurate information? We will see. Does that mean that there was information excluded from search warrant affidavits that is exculpatory or would have changed the probable cause analysis? We don't know yet. So she is trying to argue to the court that there should be further hearings regarding the search warrant affidavits. And those search warrant affidavits are the foundation of all the following warrants, and then all the following, I've knocked things over dramatically, and then all the following information. So she's trying to argue that affidavit in this case. And so she's going kind of thing by thing, saying there are too many gaps. If law enforcement knowingly and willfully misleads a court, lies to a court, includes false information in a search warrant, it is A, sometimes illegal, and B, unconstitutional, and C, then yes, everything can get suppressed. However, search warrant affidavits do not require every single bit of information in an investigation. That's not required either. So we will see what the state responds to, but this is her job, is to say these affidavits are bad and throw out the search warrant. And when search warrants get thrown out, which happens in cases, it throws out evidence. And if it throws out substantial evidence, it can change whether a case can go forward or not. But what you can't allow is fuckery. No fuckery allowed. So she's arguing that there's fuckery. The state's going to say, Your Honor, there's probable cause, there's no fuckery. And then we'll get to the bottom of it and see what the court rules. But she is going to fight on every single piece of evidence and every single warrant. That is her job. If you were ever sitting in a seat next to a defense attorney, you want them to do this. This is what you want them to do. You want them to fight. That is their job. Their job is to fight. They should fight. They should fight a lot. And when there are things that are bad in a case, these fights work. So we will see what happens. So that is the argument here. And Ann Taylor, look, Ann Taylor has done her job well. I really like Ann Taylor as an attorney. Some of her arguments are difficult because the facts are difficult for her, but she makes them well. So let us continue on. We will see what the state says. But for the I defaulted to PC probable cause. Probable cause is the standard for the search warrants. So we will continue on. She's also shared more information than we had because a lot of this is still sealed. So we will see what she has to say. So that's the fighting over the investigative DNA is a huge part of this fight, and how they got to Bryan Kohberger's name. How did we get from a crime scene with a quadruple homicide to the name Bryan Kohberger and then the investigation? How did we get there? And that's a huge part of what she's arguing here. And the court has said, right. However, it's not your client's Fourth Amendment right when they take DNA from a crime scene and then they create a pattern that can be, my words are escaping me, but can be evaluated, and they create the snippets or snips of DNA to investigate. And then they run that against, thank you, profile. Thank you, chat. Chat is bae. And then they run that against other profiles to try to find a suspect. And then they start narrowing it down. How they got from DNA at the crime scene to getting DNA from a house in Pennsylvania is the part that she's upset about, which indicates to me someone in Bryan Kohberger's familial line somewhere probably used like a 23andMe or Ancestry or whatever, because somehow they got from the DNA profile at the crime scene to enough information to go to Bryan Kohberger's parents' house in Pennsylvania and take the trash and then get another DNA and go, oh, well, that one's pretty close, and then go from there. Let us continue. So that's the argument. And the reason it's
I
kind of
do
jumping around
wanna
is because we don't have the
comment
motions in front of
on
us.
the affidavits being used by a variety of officers. I understand the collective knowledge doctrine, but that's not what is going on here. You have an affidavit that sometimes Moscow police attribute it to the person that really wrote it, but quite often it's just the name taken off, and who claims to have done the work is whoever signed the bottom of it, and it can't be the same. So it's not quite the same thing, and that matters as well. But let's talk about the second warrant. The second warrant is also AT&T. The first one comes in, and an hour later, they say they have all this data analyzed, and they say they now need 6 months worth of phone records for Bryan.
So the reason she's talking about AT&T is because today on the docket are motions to suppress multiple AT&T warrants, Amazon, Apple, the arrest warrant, cell phone data, Google, pen trap and trace data, searches of the person, searches of the car, searches of the house. But they're all really based, and I went over these, God, it's been a while now because these came out in November. They're all basically based on the same argument that the affidavit's not good. And then they took that affidavit and added some more information as the investigation went on, which is what you do. So it's at the core the same argument, but then it goes, so the argument for the first AT&T, this is why the warrant should be suppressed. Then the second AT&T, they use that because if the first AT&T warrant is bad, and then they used information from that warrant or search in the second one, then the second one can be bad. So that's when we get into like the full fruit of the poisonous tree. And the whole line of, well, if this one's bad and you used it for this one, it just trickles down. So we'll continue.
Kohberger's phone. They do acknowledge that his phone wasn't contained within the geofence when they looked at the geofence. But this second warrant,
we'll
is
talk about
important,
geofencing another day.
and we're going to talk about minutes difference of time. In the first
They are
AT&T
controversial.
warrant, in that affidavit, the police officer talks about
And if they're off, they won't be in the
2:42
geofence.
a.m. that WSU cameras, because they start looking at WSU cameras after the IGG identification, they find a white car that they say is an Elantra at 2:42. So they get the phone records, and then it becomes 2:44 that they say Mr. Kohberger's leaving his residence, 2:44 a.m. And the place near Bishop Boulevard where one could turn to go to Moscow at 2:42 is inconsistent with 2:44, but they don't correct that. They don't say that vehicle at 2:42 cannot have been the white Elantra running around that night, because we now know it was at 2:44.
Unless the time on the camera is off.
They
which
want to keep that in there because they want the car positioned like it's going to be going to
happens.
Moscow. And that is really important with the misleading of the magistrate. When you look at 1A, that's the map we looked at earlier today, where there's the whole loop around, but there's a blue line as if pointing the car towards Moscow, and that's not what happened. They then report the phone stops reporting to the network at 2:47 a.m. And that's not right. We submitted their cell experts report that say
Ooh,
the
I wanna know
phone
more about
stops
that.
reporting at 2:54 a.m. We submitted 2 affidavits to you from our experts who have worked with the call detail records. And that's just not right. Don't get caught up in thinking
so what's
7
right?
minutes don't matter here.
So what's right then?
We're talking
What's right?
about ground that can be covered in a vehicle in a short time. We're talking about two towns that are fairly close together. And so the way a car points when they go off the network matters a whole lot in this circumstance. That's not corrected in any of the affidavits. That's the part that's really exculpatory to Mr. Kohberger, is what direction, when the phone stops reporting to the network, what direction is the car traveling? And you can know that based on the cell towers, the handoffs from tower to tower as it tracks where a phone's going. The FBI knows how to do this. They chose not to do this. They chose to take a time 7 minutes before it really stopped reporting. And they chose to make a map that showed a direction that that phone wasn't traveling in, to create a false narrative for the magistrate to rely on to find probable cause.
If that's true, that might be a problem. If the map is wrong, misleading, showing him traveling a direction he's not traveling in.
Your Honor, I draw the court's attention to D7 and 8. Those are the affidavits from the defense experts. Their CVs are in D28.
The direction of travel. The direction of travel should be ascertainable by the cell phone tower handoffs and which towers you're going to, but there's a lot more information needed about that, because it depends on the tower, it depends how far the towers are, it depends how much range the towers are, it depends if the towers identify what side of the tower the phone is hitting on, or if it doesn't identify what side of the tower it's hitting on. We don't have all that information, so we'll have to see. This is just the defense argument. It raises questions. I go, that's an interesting question. And I'm curious to see what the state says. But there's a lot of information, a lot more information needed about the towers before it's, clearly this is not accurate. So curious.
AT&T warrant comes, then you end up with warrants for Mr. Kohberger's arrest. You end up with warrants for DNA samples to be taken, warrants for the search of his apartment, the search of his car, the search of his parents' house. Those are the warrants that are next implied in that. Here, what's added to that set of affidavits is the paragraph that talks about Mr. Kohberger's phone using a tower that provides service to 1122 King on a number of occasions. The PC affidavit says 12. Your Honor needs to take a look at, I believe it is D1B and C. That's an email from Nicholas Balance, and he's talking to the detective in Moscow about the dates that he says this thing happens. And then he puts those dates in his cast draft report and in his cast final report, and they don't match up. There are different dates on those, different times on those. But the really big deal about that is that it's misleading when you say the cell tower that also services this particular location. Moscow has, I think, 2 cell towers that service the town.
That was me.
Those cover.
That was you. This time that was me. Hold on. We gotta bring the screen back. Apologies, chat. There are brief technical difficulties.
Places that one shops, places
I was going
that
to
one
respond to
eats,
chat and then
places that one gets gas in
I
Moscow.
moused too far.
From that one
I'm going to
eats.
back up because she's talking about the cell towers and the area that they cover and what type of area they cover.
When you say the cell tower that also services this particular location. Moscow has, I think, 2 cell towers that service the town. Those cover places that one shops, places that one eats, places that one gets gas in Moscow. From the records, you can see handoffs, and so you know where a vehicle is going. You can know whether it's stationary or not. you can know whether it's parked looking at a particular place or not. Based on those
Oh, yes, the
records, we also provided the
stargazing.
records just so the court would know there's a volume of records. I don't expect the court to decipher those records. But based on those records, they absolutely knew that Mr. Kohberger wasn't around that residence, wasn't parked near the residence, didn't stop and have his phone in a stationary position at that residence. They
I
absolutely
think
knew
they said that
that
the
that's
phone was
not what was
off.
happening, but they put it in there to make a connection that didn't exist. They put it in there so that the judge would think that this was the right person, and they shouldn't have done that. They knew that was incorrect. They also changed that quite a bit, performed a drive testing, and so there were other bits of data
I'm
that
very
kept
curious
coming
about
in
the response to this.
so that they would know that was untrue. Now, for a magistrate to be relying, remember, on somebody who's a witness, somebody who's been interviewed 4 or 5 times, and continually says something that's absolutely impossible, has memory problems, and the judge
mean,
never knows that.
Who's to say it's
We'll
impossible?
keep the IGG identification off to the side.
Guess we'll see that later.
But then you have this false narrative that looks like stalking, that looks like following, and it's not true. That is extremely damaging. It's very misleading. It's an outright lie to the magistrate. When you omit that kind of information, when you take that context out,
If there are outright
you might as well
lies,
say
it will be a
stalking
problem.
because that's what you're trying to say, and you know that's not true.
What's in that affidavit?
This
that we
court
haven't
can
seen?
rely on our proffer in D1B and in the cast final report because those dates change. The court can rely on the evidence that will be produced at a hearing from defense experts that will talk about the handoffs, the patterns of handoffs, and how misleading that paragraph was to the magistrate. The real story is exculpatory to Mr. Kohberger. He was not stationary around that house. He was never at that house. He did go to Moscow. He did drive around, but he wasn't over there. And the phone records absolutely
He
show
did
that.
go to Moscow. He didn't go to the house, but he did go to Moscow at that time in the morning.
We'll move forward to the set of warrants that come a little bit later in February, March, April. I'm talking about Amazon, Google, Apple, those kinds of warrants that come later. Here's what is left out of all of those warrants.
And the reason I said
The fact that
stargazing is not because I was being snappy, though sometimes I am, in fact, snappy. I was not being snappy or hyperbolic. It was in their notice of alibi. That's not what's supposed to go in a notice of alibi, but it was in their notice of alibi that he likes to go stargazing by himself at night or early in the morning, and that is an alibi. That's not. You can watch my coverage on notice of alibi, but that is why, because notice of alibi. So that was in that. That's what it is. It's not hyperbole. So she's lumping together the later technical warrants that she is asking to also suppress. She's asking to suppress all of the, well, it seems like all of the warrants in this case. So there might be more, but we'll see.
Mr. Kohberger gets arrested, his gets searched, his car gets searched, his car gets searched again, and his car gets searched again. And there's absolutely no connection between him and anybody from 1122 King. And what I mean by that is that there's no blood in his car. There's no he wasn't connected to that house, to those.
She stopped
to the
herself
people in the
quickly.
house. Your Honor, I'm
Maybe I thinking of a different date for the AT&T not the cell tower stuff. Are you still talking about the cell tower stuff?
no,
She's moved.
I mean, that stuff applies to every single warrant we have because that was
I thought
early.
you transitioned to warrants that were obtained after the arrest.
I did.
Yeah, and by the time of the arrest, they had a direct DNA connection.
Your Honor, what
Yeah,
I'm
I don't know if
talking
that, I
about,
was looking down noting, so I
Other
don't know if
evidence the
that was
defense
her or
can
that
claim in
was a
cross-examination or their own
glitch.
case is exculpatory, but isn't the DNA connection in
I thought that was
itself
her.
probable cause to support any event from there?
I'm going to back up the court's question because I was talking. I thought that was her stopping herself from making that argument and going forward.
Not the cell tower stuff. Are you still talking about the cell tower stuff?
no, I mean, that stuff applies to every single warrant we have because that was
I thought you
early.
transitioned to warrants that were obtained after the arrest.
I did.
Yeah, and by the time of the arrest, they had a direct DNA connection.
I'm not going
Your Honor,
anywhere.
what
I
I'm
just need
talking
to move
about-
my fan.
Other evidence that the defense can claim in cross-examination or their own case is exculpatory, but isn't the DNA connection in and of itself probable cause to support any event from there?
Your Honor, the DNA I'm talking
I mean,
about
that's kind of the
is
point.
the lack of DNA in Mr. Kohberger's car and the lack of DNA in his apartment, the lack of connection to the
What is
individuals.
that?
Ma'am, excuse me, Anne, you argued earlier that we leave DNA everywhere. Our DNA is everywhere. That shit's like glitter. You just can't get rid of it. It's everywhere. So if DNA is everywhere and there is no DNA in the car, I got some other questions. Hey, Dr. B. Hey, G, come on. I'll mute myself. We're watching court. I am on a live stream. Dr. B said, look how enthusiastic the judge is.
Disclosed. Preclude a finding of probable cause when there's a DNA match between the DNA and the sheath in Mr. Kohberger. Isn't that probable cause every day and twice on Sunday?
Not in this context. Not in this context because of the IGG work, because I mean, that's the ultimate question that will be before a jury. What does that mean, right? What does a knife sheath at a scene mean? That's going to be the ultimate question.
Well, when the victims
Your-
are stabbed,
By
it
knife,
means
probably means a lot.
I'm just
It might.
Yeah,
It might mean a lot.
why are Judge H and I thinking the exact same thing at the exact same time? Well, at a crime scene when people are stabbed, it probably does mean a lot. Judge H. Yep, probably does.
I mean, that's the ultimate question that will be before a jury. What does that mean, right? What does a knife sheath at a scene mean? That's going to be the ultimate question.
Killed by a knife, it probably means a lot.
It might mean a lot.
Probable cause is not a proof beyond a reasonable doubt standard. It's probable cause to think that this person might have done it. And I'm not sure how that direct DNA connection to a sheath found on or near one of the victims doesn't close the book on anything on probable cause after that.
Well, I think it doesn't close the door on probable cause. I think when you know the other factual information that the magistrate should have known, I think that there's a lot of pause even at a probable cause level, Judge. This was information withheld from the magistrate, and I'm talking about, let's just go
Defeat
with
me
the
to
car.
it.
Let's just go with,
I understand the lack of evidence of DNA material.
Somebody asked if I
or
pre-watched
other
this. No, we are.
victim-related material
I mean, we're a little behind my
car
time, but live.
in his apartment as asserted, but I'm not sure how that precludes probable cause when there's a direct DNA match. There's plenty of reasons that that might be the case. And when a magistrate's looking at this, they have a direct DNA match to a person from a object likely associated with
Right.
a murder weapon. I've not yet met a magistrate would not find that probable cause.
if the magistrate had the other facts, I think the magistrate would have some serious concerns and would not find probable cause. Your Honor, the vehicle, and I know the court knows what I'm going to say, there's not DNA in that vehicle that was brought out from a crime scene. This absolutely matters, Your Honor. If you want to go to the state's theory, right, with their videos that they've talked about, they told the magistrate about, that this is the video, this is what matters. It parks at this certain time.
For those of you asking, they are talking about probable cause because that is the standard the magistrate on the search warrant needs to find. The probable cause is a reasonable belief. Is it reasonable when you have a DNA match to believe that there is a connection to the person? Is that reasonable? Most judges are going to say a DNA match is in fact reasonable. And so that's where the judge is like, okay, but if we only had this, isn't that still enough? And you go from probable cause and then it goes up the chain of higher levels of the evidence that you need at trial. But for a warrant, probable cause is what the level of evaluation is. Is it more likely? And is it reasonable? And when you get to a DNA match, is that more likely and reasonable? So we'll see.
Time, it leaves at this certain time. If you want to go to that, there's about 13 minutes of time, right? 13 minutes between the last time you see the car and the next time you see the car on the video. And if you end up with a car that's searched, and I mean searched and taken apart, the brake is taken apart, the gear shift is taken apart, the key fob is checked. There's no blood on any of that, none.
But that's not
The
till
steering
later.
wheel. There's some
It's
kind
not
of spray
retroactive.
all over the interior of the car to check for it. There's no blood. I think that there's context that the magistrate should have known. That's absolutely exculpatory to Mr. Kohberger, and it matters.
When did they search the car, and did they write a new affidavit after they searched the car? And at what point in time did they do that? Like, if the affidavits were written before, you don't take the information later and go back and say, see, this information disproves the affidavit. If that information wasn't known at the time, I need dates.
Matters a whole lot.
I'm not saying it's not potentially exculpatory. I'm just saying I'm not sure how knowing that in light of a positive DNA connection would trump, would cause any
Probable
magistrate
cause.
to say, well, okay, I guess there's no probable cause here because you couldn't find other connection to forensic evidence. When there are other things in the affidavit or affidavits at that point that could explain that, including the use of covering clothing and covering gloves and all that could be put into a bag real quick on the way out that was in one of the affidavits.
Oh, well, there's
I guess,
that.
and I don't intend to argue with you about it. I understand your other arguments, but when you get to once they have the actual DNA, evidentiary DNA, it seems to me that it's an uphill battle to say there's not probable cause at that point.
Well, Your Honor should never get to that question, but I'm going to answer it for you. But you should never get to that question because you should have already found that AT&T 1 and AT&T 2 were terrible, and there's no probable cause.
For those of you that asked, what did the judge say? The judge said, look, there is other things that would explain that result. So it's not misleading necessarily in the affidavit. And once you have the DNA, isn't that enough to get to probable cause? Because there's DNA. And any judge that looks at that is going to go, oh, well, there's DNA. Unless you're looking at a situation where the defendant would be there all the time, like DNA in the defendant's house or DNA in the defendant's best friend's house. That's going to be different than DNA in a house where the defendant has no connection. And this is a house where the defendant has no connection. So that's part of it. DNA is not going to be persuasive if it's in a marital residence and it's one of the parties, because you would expect DNA to be there. So that's not staggering. So I will stop. We're not going through a full criminal procedure class on the Fourth Amendment today, but
for those, and they just build
he was
on
saying
each other.
covering clothing.
So you should find that the very first one lacked probable cause, and then everything else does as well. But let me answer your question there. If the magistrate judge had been told there's unknown.
My point, sorry, ADHD. My point was we had seen rumblings about whether or not there was covering clothing over, or the potential for covering clothing and covering gloves and things that could be taken off easily and put into a bag. And the court said that was in one of the affidavits. So there's only one affidavit that's public. There are other affidavits that are not. So covering clothing and covering gloves is going to be important here. And if there is covering clothing and covering gloves, then how do you end up with DNA on a knife sheath? Well, if you brought the knife with you and touched it before, then that's how. But we will have to see.
Known male B in blood in the house attached to the handrail, that might have made more of a difference to her. Maybe.
I'm going to back up her argument because I interrupted her mid-sentence.
So you should find that the very first one lacked probable cause, and then everything else does as well. But let me answer your question there. If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have made more of a difference to her. Maybe a sheath that can be carried to the house and blood in the house that's not the same, maybe that matters. And then maybe the car being completely empty of any blood DNA connection, maybe that matters a little bit more. Maybe it.
Well, I'm just not sure why it matters for probable cause, but I think we're talking over each other, so I'll let you just go on.
It might matter for trial.
I don't think probable cause is in a vacuum. I think probable cause isn't one thing. I hope it's not one thing. I hope there has to be a little bit more than one thing, especially when you've
Sometimes
got
that one
another
thing's
thing
real persuasive.
that's the same as the one thing.
Well, I said I wouldn't do this, but I'm going to do it anyway because you brought up blood DNA of an
I like this
unknown
judge.
individual that was found, I think, on the handrail.
Yes.
Doesn't that necessarily not exclude Mr. Kohberger? What it may do is suggest there might be a potential other person in addition involved if you assume that that blood was related to the victims and not some earlier event in the house.
Right. I mean, depending on the college house and how many people were in and out of the house, and if people were regularly at the house, there could be a lot of DNA in a college house. It's a college house. I think the DNA on a knife sheath near a victim who was killed by a knife maybe is different. We'll see.
If what the court is saying is exactly why the magistrate needed to know that. Is there another explanation here? I've got this sheath, but there are all these other things that
It's
if I know about
reasonable.
them matter. What's the other explanation? What's going on with this investigation?
That's not the
What's
standard.
happening here? That's exactly the point, Your Honor. What other explanation is there? The magistrate wasn't given a chance to ask that. She wasn't given a chance to ask that when she wasn't told about unknown male B, blood on the handrail. She wasn't given a chance to ask about that when she wasn't told about unknown male D, blood on a glove right outside the residence. She wasn't given a chance to ask any of those questions. She didn't know that Bryan's car and the court's question, good question, what does that mean? Could it mean there's more than one person? The answer to that is, or it could mean it's not Bryan because his car's got nothing in it and there were only 13 minutes to
And
do
yes,
this.
chat, some of these are jury
The
arguments.
magistrate didn't get to know that.
Not
DNA is still on the knife sheath, though. That's the problem.
not PC
For
arguments.
probable cause purposes.
If that's the only thing she's told, I can see why she'd find probable cause. It's these other things that are withheld that create a context around it. I think the purpose of Frank's is to ask this very question, and this is a question. What do we want to do with our criminal justice system? Do we want to have one
Ann Taylor tends to argue broader societal impact and policy when the law is not on her side. When you hear lawyers arguing the case law quite a lot, it's because the case law is favorable to them. She is not arguing case law. She is going to, is this the world that we want to live in? Because the law is not on her side with this. So we have now gotten to, but this is not the world anyone wants to live in, Your Honor. If there were things in the affidavit that weren't otherwise explained, I think we'd hear her more talk about that and the case law that says if law enforcement does this, then the result is this. And we haven't heard a ton of it in these arguments. So I'm interested to see the state's response. But I've noticed that in her pattern that she kind of defaults to, but this isn't the world that we want to live in, Your Honor. This judge can't change that, but that's the argument.
thing with no context around it when there's this other context that really matters.
The Frank standard, which is even if you add that stuff, does that take away probable cause, counsel? And my problem is once you have a direct DNA tie to the defendant, for purposes of probable cause, this isn't for purposes of conviction, for purposes of probable cause, you have not explained to me why a reasonable magistrate, let alone any magistrate, wouldn't find probable cause there, even if they knew all those other facts. As to Mr. Kohberger, now, there may be, as you say, other people that creates concern or issues about that need to be investigated further. But I'm not sure that that diminishes the probable causes. Mr. Kohberger, if his DNA is found on a knife she found on or near the victim who was stabbed with said alleged knife that would have been in said alleged sheath.
I think the most prominent question is how did that sheath get there? And I think when you ask that question, I think you can have DNA on an object at a scene when you know about all of these other things and you don't find probable cause because there are more questions than there are answers. And all of a sudden, this one thing doesn't look as big. It doesn't look as everything pointing to it when you have the context around it. The magistrate didn't have to have every detail of the case, but knowing how many attempts to find a DNA connection there were, and it didn't exist in Bryan's car, in Bryan's apartment, that there's no other DNA in there other than an unknown male B that we know of for sure, an unknown male D outside. There is a lot of context there, and all of a sudden this one thing, the question of how is that there is the question that the magistrate should have had. And then we come to all of the other things that we've talked about. We've come to what we relied on. One of the witnesses saying things that absolutely couldn't be true. One of the things that the witness who said these things that couldn't be true also admitted she didn't really know anything. You can't rely on that anymore, so you take that out. You know the identification
And
to
if you
this
take it
sheath
out, isn't there still
that
PC based on DNA?
maybe seems like it would be really
Yes.
good. You don't really even know how that happened, and you don't know how it got there. This isn't like DNA in blood on the wall from Mr. Kohberger. That's not there. That doesn't exist in this scene.
Right. She's saying it
Talking
could travel.
about an item
That's
that the question
portable.
of how should be, especially when you know about the other male DNA in the house, and especially when you know about the lack of DNA connections. There's also no connection between the people in the house and Mr. Kohberger based on their cell phones, based on social media accounts. There's just no connection.
Well,
The magistrate wasn't aware of all of those factors when she was being asked to decide on probable cause. I don't think criminal justice means one piece of evidence out of the context of everything else is all you need. Context matters a whole lot.
You're not suggesting the magistrate was told that there was DNA evidence found in Mr. Kohberger's car or in his apartment. The lack of inclusion also can be viewed as the implied of, they're obviously not telling me they found this, and they would have if they did.
I'm not 100% sure I followed.
What he's saying is a magistrate is not going to assume that there's more evidence than what's in the affidavit. So if you don't tell me there's a thing, then I'm going to assume there's not a thing. So that's what I'm going to assume.
I'm not sure. Are you
I don't know
asking
why
me
the
why I
closed
think
captioning's
that's
not
important as
showing up.
far as the Frank's purposes?
Well,
I
for
don't
Frank's
know.
purposes,
I don't know where the closed captioning went.
You are implying, I think, necessarily that
It was there.
police intentionally didn't tell the magistrate that they didn't find the lack of evidence in other places,
I don't know why it disappeared.
apartment, the car, etc. Right?
Yes, that's right.
They didn't tell the magistrate that there was evidence. This is a omission.
This is one of the omissions. Yes. Yes, we have false statements and we have omissions both. It's not one thing in this case.
I was understanding completely.
Yeah, thank you for that. I wasn't following the question the court was asking.
I mean, that's fair. It's been a long day, I'm sure, for Anne.
I think the other,
Since she's pausing to take a breath, I'm going to just refresh this real quick. Where am I at? I'm at 52:32. I'm going to refresh this real quick and see if that will help with the closed captioning, because I do not know where it went. And let's see if I can find it. Did I do my timing wrong? Yes. Did my
evidence
timing
of a
wrong?
crime in there.
Hold on. There we go. All right. Now we got to find where we were in Ann Taylor's argument, because it is much argument. All right. Now we're back. So me refreshing absolutely helped.
Page
Now
281
we've just got to find where we're at in her argument.
apartments he lived in, but it was a 2015 Elantra
All right. We've done that.
with the misleading of the magistrate. When the records, you can see handoffs, and so you know where a vehicle is.
All right. That's the cell phone.
It seems to me that it's an uphill battle to say there's not probable cause at that point.
All right. We have seen the court saying this is an uphill battle. Let me just back up and see where we're at.
Well, I think it doesn't close the door on probable cause. I think when you know the other factual information that the magistrate should have known, I think that there's a lot of pause even at a probable cause level, Judge. This was information withheld from the magistrate, and I'm talking about, let's just go with the car. Let's just go with,
Okay. We've
I
seen.
understand the lack of evidence of DNA material or other victim-related material in the car and in his apartment as asserted, but I'm not sure how that precludes probable cause when there's a direct DNA match. There's plenty of reasons that might be the case.
Okay. We did see him cover
When a
this.
magistrate's looking at this, they have a
We're close to where we were, Chad.
what the court
We're
is
almost
saying
there.
is exactly why the magistrate needed to know that.
There can't just be one thing. Okay. We got,
Case. But knowing how many attempts to find a DNA connection
oh, we're close.
should be, especially when you know about the other male DNA in the house, and especially when you know about the lack of DNA connections.
All right.
Statements, and we have omissions both. It's not one.
All right. That's right about where we were. If there's a little overlap, apologies. I would rather be over-inclusive than under-inclusive at this point.
Why
right.
I think that's important as far as the Frank's purposes.
Well, for Frank's purposes, you are implying, I think necessarily, that the police intentionally didn't tell the magistrate that they didn't find the lack of evidence in other places, the apartment, the car, etc. Right?
Yes, that's right.
They didn't tell the magistrate that there was evidence.
She is saying the police intentionally didn't tell the magistrate that there wasn't evidence. That's going to be a tougher argument because the magistrate's not going to presume it exists. If it exists, you tell the magistrate. If you don't tell the magistrate that it exists, then the magistrate's going to assume that nothing else exists. What?
You are implying, I think necessarily, that the police intentionally didn't tell the magistrate that they didn't find the lack of evidence in other places, the apartment, the car, et cetera, right?
Yes, that's right.
They didn't tell the magistrate that there was evidence. This is a omission.
This is one of the omissions, yes. Yes, we
He's
have
not gonna
false
find that
statements and
as
we
an
have
omission.
omissions both. It's not one thing.
He's not going to find it being an omission saying that a thing didn't exist in this context, because they're not saying that something affirmatively did exist. The omission of something that didn't exist is like, why? But it's not there, and we're not saying that it's there. So why would we say that it's there if it's not there? Okay.
In this case.
I was understanding completely.
Yeah, thank you for that. I wasn't following the question the court was asking.
The way the court's framed it sounds bad for me, Your Honor. Please don't. Please don't. You're saying
The
that the
other
omission is not saying that something
thing-
that doesn't exist isn't there. That's not an omission. That's just, it doesn't
I think I
exist.
covered all on my proffer, Your Honor. Thank you. Sorry.
I'm interested to see what the other part of that argument is.
I think, now, Mr. Nye, were you going to address the IGG Franks issue, or is Ms. Jennings going to cover all of it?
Your Honor, I think I'm going to cover all of it.
All right, go ahead.
Going to attempt to.
Okay. Now we're moving on to the state's argument.
Good afternoon, Your Honor. As you're well aware, you have to make two separate inquiries for each of the claims that Ms. Taylor has brought before you.
The standard.
First, you have to decide today, has the defendant made a substantial, not just a preliminary showing, but a substantial preliminary showing that the affidavits, and in our case, we're referring to the Exhibit A's that were attached to each of the affidavits for probable cause, that they were the basis, which were the basis for multiple search warrant applications, that within those Exhibit A's, there were deliberate or recklessly false statements or omissions. This is a high burden, and this is a very high hurdle for them to jump over. Now, if you can answer yes to that, then and only then should we move on. And then ask the second question, does that even matter? Does that statement actually diminish the probable cause finding? It's only when the answer to both
court's
of
already
those
signaled how he
questions
feels
is
about
yes,
that.
should you then even consider granting a Franks hearing. The motion for a Franks hearing is a serious allegation. The allegation is that law enforcement acted improperly, that they lied to the magistrate in order to secure the warrant.
Ma'am, we know the standard.
The statements have to be deliberate, reckless, false. That's the standard. Franks is not implicated
You might
by
need to
just
get
simple
1.25.
mistakes or misunderstandings about the evidence or Scrivener's errors or even just negligence. As the court is well aware, this is serious. The defendant is alleging law
reading your
enforcement
notes?
lied to secure the probable cause in this case.
Please don't read your motion.
And the state submits the defendant has failed to back up this claim. And they failed because they can't. Law enforcement submitted probable cause affidavits to the
Give it a minute.
magistrate based on the information they had available to them at the time that the various applications were made. That's how it's supposed to work, and that's how it worked.
I think she's reading, and that's why she is.
The
speaking
defendant has
slowly.
alleged 13 separate areas
I mean, it'll be organized.
where they say there's a Franks violation. I'm going to go through those so that I make sure that I get through each of them in the same order that defendant addressed them in their motion and as the state addressed them in our response. And that starts with this idea of attacking Exhibit A.
I mean, no shade to reading. She is addressing not a million. She's addressing numerous different affidavits with numerous different attacks to them. So it's not shade that she's reading. It was me trying to understand why she's talking not at rapid lawyer speed. And I think it's because she is going methodically through the arguments. But 1.25 speed, motion granted, because she's going to be easy to understand at 1.25, and we're going to go through each point, which I'm interested to hear.
As the court knows, in Latah County, it's our practice, we submit an affidavit for probable cause.
That's better.
As I said, attached to that affidavit is what we call an Exhibit A. That Exhibit A is law enforcement officers' statements, laying out all the various facts known to them related to probable cause in order to support the issuance of a search warrant. In this case, Exhibit A, by the time we get to where we're challenging, was about 20 pages of facts for the magistrate to review. Essentially, the same Exhibit A was relied upon for the.
Well, that's information the defense didn't mention, not even once. Not even once. The defense is saying that the affidavit didn't say that evidence wasn't found in places where evidence could be found. And the state is saying in every affidavit we submit, the affidavit summary has an Exhibit A, and the Exhibit A has the known facts. And the known facts in this case, by the time we get to the warrants that are being challenged, that Exhibit A is 20 pages long. So there's an affidavit, but the affidavit is completed with the 20-page factual breakdown that is attached. That wasn't addressed once in Ms. Taylor's argument. That feels like some information that's necessary context. If we're talking about should the magistrate have all the context, it sounds like 20 pages of an exhibit is a lot of context, unless there's information that's known that was not submitted.
Application of multiple warrants. This was a massive investigation. You heard testimony earlier today from Detective Payne. Multiple officers were involved in this investigation from multiple agencies. And they were doing briefings. For weeks at a time, they received 2 briefings a day with all the lead investigators in the same room receiving the same information. This information was then put into this Exhibit A for the basis of a probable cause affidavit for search warrants.
They had a large working doc.
A working document like this with the most up-to-date information was the best way to ensure the magistrate was getting the most complete and accurate information. And defendant wants to take issue with this process. But
What do I do if the affidavit is attached to
Keep
Detective
listening.
A's submission? Is it Detective A's affidavit, right? And there's for purposes of my question, a material reckless statement in there. But Detective A isn't the one that made it. It was another person on the team, let's say the cast member expert.
well,
How does that affect the Franks analysis as it relates to the affidavit submitted by Detective A?
I would say that Detective A would have to have reason to know that that was a materially reckless statement made by Detective B.
Even if the person that made the statement on the team knows that that statement going into the affidavit, the group affidavit, if you will, or the group statement is going to ultimately make its way to the magistrate?
I'll concede I think there's an issue there.
Mm-hmm.
But that's not what happened. I don't think that any officer can submit a statement that they know is going to go in front of a magistrate and do so recklessly. And if they do so, then I agree that the court should take issue with that. But the cooperative nature of this investigation and this kind of group effort is allowed. As discussed more extensively in the state's response, we have several Idaho cases that support this. State v. Rubio, State v. Gomez, State v. Alger. And in our case, the probable cause affidavit, it wasn't as if the judge wasn't put on notice that this was exactly what was happening. The judge was put on notice. Each affidavit explicitly told the magistrate, blank officer, depending on who was applying for it, quote, is being assisted by members of the Idaho State Police and agents of the Federal Bureau of Investigations. Throughout the document, it makes references. I consulted with FBI Vehicle Specialist S.A. Imel. I consulted with FBI S.A. Balance regarding CAST. I consulted with FBI S.A. Hill regarding surveillance footage. It's very clear what the sources of the information were coming from.
In the
It
document.
could absolutely be reasonably inferred where the information was coming from. The magistrate was not at all misled regarding the sources of all the information. I'm going to talk a little bit about this idea that there's some issue with who did the work in reference to Google. They claim that the CSLI work alleges Kohberger around King Road residents. And this same claim is an Exhibit A signed by Detective Blaker.
Remember, I
Well,
do have this at
This is
1.25.
inaccurate. The officer signing the
I
affidavit.
do have this at 1.25, and there are a few little glitches in the court's Zoom. So thank you for your patience when there were things that you're like, wait, what? The glitches are harder to pick up when it is at 1.25.
David did not claim to do the cast work.
Did you mean AT&T?
Yes. They didn't claim to have gotten those records and put them in to their program to determine the approximate locations of the phone. That was done by Special Agent Balance. And the affidavit makes that clear. And defendant ignores the entire paragraph within Exhibit A that makes that clear. Quote, I consulted with an FBI special agent that's a certified member of CAST. This paragraph goes on to explain what CAST is, what CAST does, the experience that's involved, SA Balance's own experience. And then the law enforcement officer then states, from information provided by CAST, I was able to determine estimated locations for the 8458 phone.
All right, Chad, I'm putting the desk up.
That's not
Hold
claiming to
on.
have done the CSLI work, but instead is just a reflection. The work was done by Balance. Investigators reviewed that and then made some determinations of the approximate locations for that 8458 phone. And we're going to get into this in a little bit down because this comes up again. All about the cell phone. And we're just going to take we have two different opinions about what those records show. We have an expert who tells us, and that's what was relayed in the probable cause affidavit. And those opinions haven't changed. We differ on a few factual issues. I believe there are 3 towers that provide service to the Moscow area. Defendant is cool.
Here's my concern with you telling me that at this stage of things. Where in the record is that currently? Apart from anything you may have submitted after they filed the Franks motion,
What specifically?
that there are 3 towers.
I believe
Remember,
I
we're
referenced
at
it in my
Proffers.
response.
Yeah, but
This court has a
if you
very
give me
good
evidence and I
memory.
rely on that evidence, then I have to give them a full Franks hearing. And so that's why I've been very clear to say I'm looking at what the proffer is from the defense
Right,
without evidence submitted by the state
right.
to determine whether they have met their threshold burden. And so
Right.
I get concerned when you start telling me things that are not necessarily part of the evidence.
Understood.
The court is a
We can-
redirect.
We can move past the number of towers.
The court's like, redirect. Redirect.
Here's what is in evidence, though.
Redirect.
And based off of the PC affidavit, is that the phone was in the area for the tower that provides service to the 1122 residents. Still maintain that's true. Regardless, none of this has any bearing on the validity of the search warrant. Their argument is merely a clarification about which member did what work. And that doesn't matter to the ultimate determination for probable cause. Defendant then makes some allegations regarding an eyewitness statements.
The reason the court redirected her is because the court said, look, if you are going to submit additional information that's not in the record, then they get a hearing and we have an evidentiary hearing. The court's like, we're not going to do a full evidentiary hearing with all these witnesses if we don't need it. This is a multi-step process like we've seen in the Karen Reed case. You have the hearing to determine if there's going to be the Daubert hearing. And then if the court decides that that's necessary, then you have the hearing. That's the same thing here. We need to decide if there needs to be a hearing. And they're trying to do that threshold analysis before you get to the second part. And the court's saying, look, if you're going to rely on other stuff, then they're going to get a hearing. So the court's just like redirecting that. And I've seen lots of you in the chat ask if that is Runkle in the courtroom. I don't know if Runkle is still in Vegas after winning a Gundy, but I do not believe Runkle is in the courtroom. That is not Runkle in the courtroom. But I don't know if he is still in Vegas for the Gundys or not, but not in Idaho. And I don't know if Idaho is any warmer than Canada, but the chat is saying he's still in Vegas. Yes, Runkle is having a good time in Vegas and not in the courtroom.
Related to DM.
So now
There's
we've moved
kind of
on
two
to
buckets
discussion
of
about the
attacks
witness DM.
The first bucket is that the defendant claims the magistrate was never informed that DM told law enforcement she, when shown a picture, didn't recognize the defendant. Well, it's clear from reading the probable cause affidavit that she's not going to recognize the defendant.
What relevance was the statements of DM that were included in the affidavit as to probable cause?
I cited those in my response throughout.
What were they?
Okay.
She's
I
like,
can tell you generally,
Your Honor, I don't have that with me.
she gave the same set of facts.
I understand the things that she said. Why was it important the magistrate know those things?
I think the court's getting it, that it's not. But I'm going to slow this down because as we are talking about the witness in this case, the defense talked about it quite a bit. I'm very interested to see what this attorney has to say.
In other words,
I slowed her down
are
a
they
little.
going to who the ID of the perpetrator is? Are they going to establish a timeline of when the...
I'm going to back up.
Throughout,
What were they?
okay.
Nisha, yes, DM is one of the roommates.
Generally,
One of the surviving
she
roommates.
gave the same set of facts.
I understand the things that she said. Why was it important the magistrate know those things? In other words, are they going to who the ID of the perpetrator is? Are they going to establish a timeline of when the alleged or when the murders took place?
Yeah, what's the
So it's
relevancy
part
of
ID as well?
DM
I
statements?
think that it goes to giving a general description of the person that she saw in the residence around the time that corroborates when we know these crimes occurred. Yes, a general description is material and relevant. And that general description, which is what was provided in the PC affidavit, was consistent throughout all of her interviews. She described seeing someone wearing all black, a mask with only a portion of their face showing and visible. This person was male, white. She heard a voice that was not something that she recognized. The person was a slim, skinny, lean build. And the person was taller than she is around 5'8". That's what's important, It was that general description. And that general description did not change.
It's also important to establish the timeline.
It is. It's important to establish the timeline to know when that the timeline matched the vehicle surveillance of when a suspect vehicle is coming into the area of 11:22 and then leaves, as well as text communications of her relaying what she's observing during the same time period.
Texts of what she's observing and when she's observing it are very interesting to me, because those will be timestamped.
And even if the state's wrong, that somehow there was some exculpatory relevance to some of her statements not being included in the probable cause affidavit, you can take all of it out and the magistrate would still have probable cause. The second issue defendant, the second kind of bucket that they take issue with DM, is about these other just statements that she gives during her interviews. The defendant argues when an eyewitness states she's not sure anything she saw was real, a magistrate should know about it. Well, the simple answer is investigators knew what she saw was real, and we know it wasn't a dream because they found the evidence discovered the next morning. Those statements didn't need to be included in the PC affidavit because they weren't exculpatory. They didn't support this idea that this didn't really happen, that somehow we got it wrong. Next, defendant attacks the vehicle identification.
All right, I'm going to put her back to 1.25 now that we're done hearing about DM, the roommate. There is much that we don't know about the roommate, what the roommate saw, what the roommate did, why the roommate did it. I'm not going to speculate on it because it's going to come out at trial. But yes, there is much that is unknown. There are questions that I hope are answered at trial, and we will see. But let us go to 1.25 because we are now getting into vehicle description, and I don't need the well, Your Honor, we know it wasn't wrong, because the next day we can just, okay, ma'am, all right, I got it. Can we just let's keep
Picture
going.
they're painting about how this happened just is simply not true. The magistrate was given a very detailed picture of the investigation at the time related to the white sedan, which was later determined to be a Hyundai Elantra. This was about 5 pages of the probable cause affidavit. The reality is, still images and video were provided to a vehicle specialist. Based on his review, he provided information to investigators that the suspect vehicle was likely a Hyundai Elantra. There was some discussion regarding what was the most appropriate year range, but at the specialist direction, he said that the year range to be focused on was 2011 to 2016. So Detective Payne reasonably relied on his expertise as a vehicle specialist and included that
I'm going to
in
start
his probable
singing
cause affidavit.
Pain Lies by the
And the court has in
Riverside
front of
in a
it
minute.
the emails attached as exhibits that show that's exactly what occurred.
My
And
shoes
the
back
defendant
on.
appears to argue that, well, the vehicle specialist shouldn't have relied on this video because they can't tell that that was a Hyundai Elantra. To them, it doesn't look like, I guess, a Hyundai Elantra. And the video that is clear, well, they take issue with that video because, and specifically, we're talking about 1125 Ridge Road, because they say, well, that can't be surveillance video of the white Elantra, even though it was caught on video about 0.3 miles
I
from
like
the
her
crime
presentation
scene,
more when she's off her
about
notes.
3 minutes right before when we see the suspect vehicle enter the area of the crime scene, which 0.3 and 3 minutes appear to be the amount of time it would take the vehicle to travel to the area of the crime scene, they say, well, that can't be the right video, because if it were, then the surveillance right up the street would have also caught this video. But we know that's not true. And that's been submitted to this court. Excuse me?
When was it submitted to this court?
Well, it was submitted through my response.
I was afraid that you were going to say.
It was submitted through my response, that their logic is flawed. And I can tell you,
The court's like,
it
I
has
can't
since
rely on
been
new
confirmed.
information.
I do not have, and it has been discovered to defense.
The court's like, I can't rely on new information,
We
ma'am.
had Special Agent Hill confirm, and he discovered this as Bates 15990,
The court-
which confirms
the
that
court's
the
like, shit. Stop.
surveillance camera that was set up to capture motion would not have captured the corner the defendant.
This is why the judge is annoyed. The judge is annoyed because he's like, I'm not considering things that were not on the record for the magistrate, and I don't need to. And did you not listen to anything I said to defense counsel? And if you keep doing this, we are going to have a hearing because now you're trying to give me other information. And at the heart of this isn't the DNA enough. Do not own gold this, counsel. And so the court's just like, stop it. Stop it right now. Stop it right now. So he's like, ma'am, back up off of this point. Let it go. Like, pick up what the court is putting down. So we'll see what happens.
It says must have been necessarily captured. Again, it doesn't matter. At the end of the day,
That's the
the
point.
the
court
defendant's
wants to get to.
speculation
It
about
doesn't-
the route of travel
correct.
and their differing opinion on it
That
isn't the
point.
basis for a Frank's hearing.
Yep, that point. Back to that
There's
point.
no legal basis for
Back-
second guessing a vehicle specialist's opinion.
Back to that point.
And they haven't made a substantial or a sufficient proffer for you to do that.
She
Next,
wants.
the briefing addresses the IgG issue.
It's hard. Like, I get where she's at as a lawyer. It's hard because she's like, no, Your Honor, what they're saying is not true. And we know it's not true because blah, 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 blah. You don't get to do all of that the way she's trying to do it here. But it's hard in an adversarial proceeding to not, when you have the receipts, to not argue the receipts. It's difficult.
And
Is it possible to tell from the affidavit what shots and what cameras were relied upon to make the identification?
I know that I don't know that you needed to. I don't know that all of that information had to be included.
That wasn't my question. My question is whether the
Right.
affidavit describes the specific shots and cameras relied upon to make the identification.
No. It discusses that several surveillance videos were reviewed, that images were turned over to a vehicle specialist, and then that specialist made a determination. But no, we didn't walk through describing each and every still image or video to the magistrate. No.
Because we
Nor
don't
did
need to. Right, because we don't need to.
Really, the IgG has been discussed extensively. I think the only real Frank's issue is, should the IgG process, the fact that it was not included in the PC, is that the basis for a Frank's hearing? But you heard testimony today that law enforcement received this tip and they made a strategic decision not to include it.
There was a tip.
They were told it's only a tip and that they should develop probable cause separately. And that's what they did. And at the end of the day, Your Honor has already kind of hit the nail on the head through your questioning of Ms. Taylor. At the end of the day, this information regarding IgG and the use of IgG is only inculpatory. And the non-reliance on the IgG information does not diminish probable cause. And the IgG information was confirmed through the STR testing.
And that's really
I
the main
can't
point.
wrap my head around any argument
I mean, that's
that
the main point.
IgG and STR testing would be exculpatory. Defendant makes kind of hay about the dog barking. And
Did
that
she
I guess the
just-
magistrate should have been informed.
Did she
that-
just say that the defense makes a lot of hay out of the dog barking?
that a dog barked for 25 to 30 minutes? And this is just a reach for me. I'm still unclear how this is exculpatory. And again, this fact just does not diminish. Take out all information related to the dog. It doesn't diminish probable cause.
The chat wants to know more about what
Circling
happened
back
to the
to the cell
dog,
phones,
the well-being of the dog. We have lots of questions about the dog. We want the dog to be okay.
At the end of the day, this is the proffer.
We want to know
is their
the
opinion of
dog's
the evidence.
name.
That's not the basis for a Frank's hearing. We're relying on our expert's opinion. They disagree.
We have questions about the dog.
And that is a dispute that should be had, and it should be had at trial. And I suspect it will. But it doesn't give you the basis to grant a Frank's hearing. Defendant next, the next area is the footprint. There was a footprint found outside of DM's bedroom. They claim that the inclusion of this was misleading. But again, there's nothing misleading about the statement. The statement says during the process of the crime scene, the investigators found a latent shoe print. It was located during the second processing. It came back using a presumptive blood test and showed the presence of cellular material. They let the judge know that it was outside the door to DM's bedroom located on the second floor, and it's consistent with her statements. Yeah. The investigators provided the magistrate the information they had at the time of the investigation. Defendant's opinions about where the shoe print should have been located and it couldn't necessarily have been located there, again, that just doesn't rise to the level to warrant a Frank's hearing. Again, our case doesn't hinge on the identification of the shoe print. Neither did the PC affidavit. There was sufficient probable cause with or without this information. I'm going to address grand jury subpoenas. They didn't discuss it today, but it's addressed in their motion.
Yes, before you get to that, can you address the allegation that the cell phone data was, I guess, purposefully erroneous as to the time that the phone was no longer reporting, which then relates to the supposed
I love that the court's like, let me
Position
stop you
found.
there.
Right. Well, I don't know that I completely wrap my head around the defendant's logic in this.
I have to, so help me out.
I still don't understand.
I understand her statement and her argument. I'm trying to understand your response.
I guess what was reported was the information known at the time that the probable cause affidavit was given.
By
There's-
Detective Payne? Or by
The
the cast member?
information that he was given from.
This goes to my first question about imputed erroneous statements.
I'm going to slow
So I understand the allegation.
them down because the court, like me, does tend to jump in when excited to ask a question or make a statement. And I don't want to miss the point of his argument. And he was like, go back up for me. I know you don't understand the defense argument, but I have to understand the defense argument. So I need you to answer the defense argument. I also need a record. Can
was
we
given.
talk about it?
There's
Detective Payne? Or by the
the
cast member?
information that he was given from.
This goes to my first question about imputed erroneous statements. So I understand the allegation in that regard, not necessarily to be that Detective Payne knew the statement was wrong, because I'm not sure there's evidence of that. But did the cast specialist know that there was a misinterpretation or an erroneous report?
I don't think that, I don't I don't think that you have before you a sufficient proffer that proves that the cast specialist submitted false information. Apparently, there's a difference in the handoffs of 7 minutes. At the end of the day, okay. No, I don't think it's incredibly material.
Well, the
Material,
defense
if you
does.
look at it in terms of where the phone was in that 7 minutes.
Well, it's
If
material.
Going a direction different than what your affidavit says it was going, isn't that material?
The
And the car?
direction of travel, like, yes, I would say it was if it was found outside of Pullman. It was not. It was reporting to a tower in Pullman. This assumption assumes that cars can't change direction of travel. We're assuming that then the same cell phone, which was then turned off, isn't then also tied to the evidence where we do have information to believe a white sedan tied to Mr. Kohberger is then found on surveillance. We're not talking about 7 minutes. We're talking about 7 minutes at 2:50 in the morning which is about an hour, approximately a little over an hour before the crimes occurred. I don't follow the logic that this 7 minutes, an hour and 10 minutes prior, proves that there's no way the defendant couldn't have traveled the 7 miles to Moscow, whether or not the car was pointed in a different direction or not. It's a leap for me. Does that answer?
His face says
your
no.
answer, so.
Does that answer your question? Well, that's your answer.
Let's say it was. Let's say that it was exculpatory. Let's say it was materially that it was false. It was recklessly included. It wasn't, but let's say it was.
That's an interesting hypothetical.
Well, the magistrate still had enough information before her.
She's defaulted to the arguendo.
To grant probable cause.
Even if it's all bad.
So we still
Still
don't
doesn't
get
matter.
to a Frank's
Right.
hearing. Even if you want to make that leap. I can quickly go through grand jury subpoenas. At the end of the day, their desire still, this has come up several times throughout this process. Their desire to see the actual grand jury subpoenas is not the basis for a Frank's hearing.
No, it's
There's just
agree
simply
with
no
that.
legal basis to support that idea. And there is nothing obtained that was obtained in violation of any of the defendant's constitutional rights. They say they needed to know the scope, but it is not clear to the state how that would have made any difference in the probable cause determination or why the magistrate would need to know that. Again, this just appears to be another attempt by the defendant to try to obtain these federal grand jury subpoenas. And I submit to you, Frank's is not the proper avenue.
Federal grand jury subpoenas.
We're going to go to lack of connection. I think this has already been addressed by Your Honor. At the end of the day, this fact just has no bearing on the probable cause determination. The investigators relayed the known information they had at the time, and timing is important. At the time of the application of most of the warrants, The evidence taken from the defendant and his vehicle was still being reviewed. We didn't know if there was a connection. Only a few warrants even fell outside of that. Apple, YouTube, Instagram, TikTok, PayPal, and Microsoft.
YouTube's included.
However, even for those warrants, the state submits to you that fact's not necessarily exculpatory. The defendant's belongings and the vehicle were recovered approximately 6 weeks after the homicides. And that fact was known in the probable cause affidavit. It could be reasonably inferred. But to the extent the court believes that law enforcement should have included this information, again, I can accept that, but it's not enough to outweigh the balance of the information that was included that did establish
Right.
probable cause. I submit to you the defendant has wholly failed to establish a single false statement or omission without which the magistrate would not have found probable cause. I ask that you deny their motion for a Franks hearing. Thank you.
Rebuttal. Briefly.
He said briefly. For all of you that are like, this judge
Try to do
is
my part to make you so that you can and
this judge
avoid
is
asking questions.
Sir Sassafras. If you have not seen the very beginning of this case with this judge after the change of venue motion, just remember this judge started the very first hearing in this courtroom with this case with, I would like to tell you all I'm happy to be here today, but let's not start with an untruth. That was his first statement to these lawyers. So this judge has come with the sass and the do not waste my time and the I'm not even supposed to be here today energy when this case got assigned to him. And he's just like, look, what we're not going to do. So for all of you that are like, well, this judge is a bit sassy. Yes, he is. And then he goes through very much the appellate court process is tell me this, tell me that, answer this, answer that. He's just not having it. I wonder if this judge is like, I am not ready for all of this shit show. But I also think he's been very fair. He has moved this case along without much fuss, and he has been timely in his rulings, and he has not wasted the attorney's times. He has been very precise in moving this case along.
Motion for a Franks hearing. Thank you.
So the burden is with the defense, which is why the defense gets to reply.
Briefly.
I'll try.
Briefly.
I'll try to do my part to make you so that you can and avoid asking questions unless I'm truly stumped.
He's like, I'll try to be quiet.
Before I get started on what I want to tell you, in response to what the state said and then my summary, I'm curious about the new police report that was talked about. I didn't see it in the submission given to your honor.
I've had such an avalanche, I can't think of what it is off my head. If it did, it certainly wouldn't be part of the analysis for the court in determining whether or not you've met your showing to have a Franks hearing.
Well, that's good because it occurred after my Franks briefing came. So I didn't get a chance to respond to that yet. All right, let's start with the grand jury subpoenas.
His
and,
memory of the facts of this
yeah,
case
we
is
wanted
pretty
those in
impressive.
Discovery. We didn't get those. We were told no a couple of different times.
But avalanches.
The issue
fair.
with that is that at least one of the warrants was used, the returns from the grand jury subpoenas, it used the return from the grand jury subpoena to obtain information, and we don't have those, so we don't know the scope and parameters of that. So the magistrate relied on something that's not reviewable by us, and that's kind of gotten to be.
Amazon.
Sorry.
Is that Amazon?
It is Amazon, Your Honor, and the return on the search warrant says that they already produced them pursuant to something else, and the affidavit says, we saw these things, so now give them to us in a search warrant. That just seems to be problematic to me. It's kind of the same thing that's laying on pretty thick here. You can't have it. We're not going to tell you about it, but don't worry, we didn't do anything wrong. And that's a problem. That's a theme of this case, and that's really a problem. So I think we should have Frank's hearing to explore what that really is about.
That's
if we're
What's
necessary.
the omission?
That's a discovery
or the
hearing, though.
Misstatement that you're, as it relates to the Amazon warrant.
The omission
That's
is
not Frank's territory.
the FBI used the grand jury system and obtained this information outside of the warrant process. But for some reason, we need to come and get a warrant because nobody gets to. I have them in other cases, Judge. I don't know why they're withheld here. It makes me really suspicious.
I mean, I guess from a Frank's perspective, though,
Wrong hearing, though.
the question is there a material intentional misstatement or a reckless misstatement?
Right, that's a discovery hearing.
Frank's perspective,
Right.
was it material? Well, it was relied on to get the warrant.
And when I
right?
keep saying that, I'm not saying it might not be a problem. It might be a problem. We don't know. But court has processes. And so the court's like, ma'am, this is a Wendy's, which apparently is going to be doing Thin Mint Frosties next month. I keep seeing them on social media. But that is not the point. I'm just ready for dinner. That's a different type of hearing. So it doesn't mean that it's not a problem. So I'm not saying that it's not. It may be, but it's not a problem for this hearing. It's a problem for discovery hearings. And if they don't get a Frank's hearing and move to discovery hearings, then we can see them say, but Your Honor, they didn't turn over this information. Therefore, it should be excluded for discovery violations. And that's a different problem. So not that it's not a problem. She's like, Your Honor, this is really suspicious. He's like, okay, fine. But how does it apply to whether or not you get a Frank's hearing, not a discovery hearing? So that's the thing. Process, procedure. We're here for the one thing. We don't get to go do the other things.
It disclosed to the magistrate that this was the result of information given as a result of a federal grand jury.
Also, clearly
It
my
absolutely
algorithm,
was.
clearly my algorithm is dialed in. If I'm hearing about the Thin Mint Frosties and y'all aren't, I'm going to find the date for you.
Suspicious.
I mean, I guess from a Frank's perspective, though, the question is there a material intentional misstatement or a reckless misstatement?
Frank's perspective, was it material? Well, it was relied on to get the warrant, right?
It disclosed to the magistrate that this was the result of information given as a result of a federal grand jury.
It absolutely was.
What did they say that was not true, or what did they fail to disclose?
I think they failed to disclose the
The
parameter
rumors are
around
saying
that grand
February
jury
for the Thin
subpoena.
Mint Frosty. Everyone. Right.
How is that? Well, I understand. I promised I wouldn't slow you down, so I'm going to let you just go ahead.
Okay.
He wants to keep arguing this point. He's like, no.
I'll go backwards. The 7 minutes that's not disclosed, that's intentional, that's not given to the magistrate to make the decision. There are a lot of these things that are intentional withholdings and a lot of things that are deliberate. You heard a lot earlier today about the hours of meetings that took place and the decisions to keep certain things secret. So I think we've satisfied the prong of deliberate and intentional withholding from the magistrate or deliberate false statements to the magistrate. on all of those areas. I want to talk only about a couple of other things. The credibility of the witness that they talked to, the one that they cited information from, that was relied on. That appears in these affidavits, and it's relied on after Mr. Kohberger's identified to say, well, he has bushy eyebrows, so this person has to be right. It's relied on when the police officers put into the affidavit that the footprint that I didn't talk about on my first one. We gave the court the photographs of it. I'm happy to give the court these. That's a misleading statement to the court or to the magistrate that was asked for probable cause. This footprint is at the very edge of the door. It's a single footprint and it's not repeated throughout the house. So to act like that bolsters this witness is really important, especially in context of the misstatements of the witness. I want to go through these. I won't read them in their entirety to the court, but Your Honor asked the prosecutor what they were. And I counted up, and at the very first
Hold on.
interview,
I'm gonna
remember the
go-
issue was whether or not one of the victims ran downstairs. And she didn't say it once. She said it
We are on normal time. I thought Anne was sped up. She just talks much faster than the prosecutor, which I
4
appreciate.
times
I wanted
in
to
a
hear
row
the
in the very
statements.
first interview, and that just didn't happen. It just couldn't have happened. And that was not told. In fact, that statement was brushed over and withheld from the magistrate. About the memory issues in the second interview the same day, there are 2 references to not remembering. A couple of days later, there's the third interview, and there's references to not remembering, being drunk, a statement, I don't know any of it. Like half this stuff, I don't know if it's a dream or if it's real. That's at page 399. At page 406, I don't know if this was real or in my mind was just like playing with me. But from what I think I heard, someone was crying in the bathroom. These are definite statements that were not given to the magistrate and in fact were brushed over. And credibility is really, really important when that person is relied on in the investigation. So let's talk about the vehicle. The court asked some questions about what the magistrate could see in the PC affidavit. The way it's laid out would cause one to think that the vehicle's identified on the camera near the house, and that's not so.
So it's misleading.
It's not identifiable. The state's expert said it's not identifiable from that particular video. It's piecing together the other videos that they come up with something.
What's the evidence that law enforcement relied on the Ridgewood footage to identify the vehicle?
What did they rely on?
What's the evidence that they relied on Ridge Road, which you say doesn't show anything? What's the evidence they relied on that to ID the vehicle?
They relied on the Ridge Road camera, and you can see that in the emails from IMO and the other law enforcement officers when they say they have Paradise Creek Road, and then they say we finally got a good one, and it produced to us is the 1125 Ridge Road footage and photograph, and that's the only one that you can make a positive ID on the car.
Where is that in the record?
The 1125 Ridge Road. Well, it's in our discovery.
That's a hard question.
Is it in the motion? And
I believe we put a picture of that in our motion. I can look at it's in my original memorandum. I think there's a picture of that. Let me grab that page for you.
The judge was like, great. Thanks. That's great. If Anne's flipping papers, I'm going to zoom, even though she and her co-counsel were talking. If we're flipping pages, we're zooming.
Of the amended memorandum.
that's just the photograph,
Yes.
but not the information that ties that to the Ridge Road camera?
Your Honor, it's tied by our argument based on our review of the discovery. I don't have an affidavit from any police officer saying it was that.
Oh,
I probably don't have an email other than the ones from Immel and that transaction that we did provide for the court.
this court's
That
memory
was
is
the
so
video that the identification was made
good.
on. That, I'd love to know more about that as well, Your Honor.
Because what this court did is say, where did you provide that to me? Can you show me where you provided that to me? And she goes, we've connected that by argument because the court knows that it's not in the filings. And so in the court asking, where did you provide that to me? It forces her to stop and say, we've just made that an argument. It's not in our filings, because he knows it's not there. And he's just going to say, I know it's not there. He's going to have her say it, which means that his memory for these facts has been incredibly impressive. Just incredibly impressive.
But that's not the standard.
I understand that. I understand that. I would refer the court to our exhibit with Agent Immel's communication. I believe that is going to be at D9, and then the pictures contained in the Frank's motion. Let me talk a little bit more about IGG, even though we've done that all day long today. I would remind the court that IGG doesn't identify a person. It suggests a family group, and an investigation can happen from there.
Which is why there's no Fourth Amendment
But
right
nothing
in it.
happened until the
Mhm.
IGG happened behind the scenes and in a closet. That brings
That's
me
About
to
the end
talk
for today,
about
folks.
the
No,
intentionalness of this in an overview.
no.
And the court should look at the entire picture of what's
Okay.
happened. It's a long investigation. It's a complicated investigation, but you have law enforcement repeatedly meeting, and you have FBI
Yeah, those
agents sprinkled
IGG
in.
arguments aren't going to
And
work.
there are a lot of things that you've heard about today that are withheld, that are super secret, that nobody's going to talk
It's not
about.
a lot just because you've repeated it
And there's a
multiple
lot
times.
of meetings that are happening, particularly around the IGG. That's a definite, we're not going to put that in there. But there's also the communication about the AT&T records, about what do those phone records mean? What does it mean when there's calls being handed off, or phone tower reporting being handed off to track a vehicle? What does that mean? There's communication about that.
Double
There's
rainbow.
review of the videos together. And what these things mean is that a partial picture was decided upon, a picture that left out a lot of detail, a picture that gave false statements to the magistrate to get probable cause to get that first AT&T warrant. That was, the officers went back and forth talking about what kind of statements to use. Statements were changed to be included in that, and definite decisions were made at that time. The decision was made to leave the witnesses' statements in as they were, even though there had been interview after interview after interview, and they knew those were incorrect. The decision was made to build a false investigation and leave out the super secret IGG part. And that decision was made based on the behavior of the agents and based on not wanting anybody to review what they did, so that we could check their work and see if they did anything right. That just continued with decisions to leave things out in this case. Probable cause doesn't get
I don't think she's shown
determined by one little
that
thing
statements
without
were
context,
changed at this point.
especially when there's context of omitted information. That's why we have the opportunity for a Franks hearing, to ask for a Franks hearing and to offer information for your honor to rely on. It is imperative that there be integrity in the warrant process. There's a lot of power
That's true.
in going to a magistrate and having no attorney there, nobody to cross-examine, nobody to question.
Because
There's a lot of
it's,
power in that
probable
to
cause.
obtain a warrant. And there's a lot of danger when there's that much power too, to leave just a little out here, to add a little more here, and go get a warrant and then build everything that comes from that. And that's what's happened here. Your Honor, we ask for a Frank's hearing to more fully explore these. The court can see this is a massive amount of information.
Oh,
The
no.
court has 1,000 pages.
Wow. The court has
These aren't just
1,000 pages.
that we made up. There's a lot going on.
That's
Here.
on the court's
I mean-
end. When the court said I have an avalanche, what he meant was 1,000 pages of the defense filing. So it's fair in future when I complain about something being over 100 pages long in a single court filing, you can say at least it's not 1,000, because damn.
Need to have a hearing to fully explore this.
Court's like,
We
no, I
will
don't.
Adjourn Frank's, take the Frank's proffer under advisement, issue opinions on those forthwith. We will pick up tomorrow with, trying to think, we're probably at the evidence on the motions to suppress tomorrow, correct?
Yes, Your Honor.
All right, I'll see you in the morning.
All right. And with that, we will be back tomorrow morning, it seems. So that is what that's what's going to happen. Hold on, let me turn this off so it doesn't autoplay something else and scare the crap out of me. So I think my white balance changed when I moved my desk, but that's okay. We're just going to finish up here because it has been 3 hours and 41 minutes talking about this. Court TV in the chat said, we always catch the end of the live. Court TV, can we chat? Can we ask Court TV for a favor? Court TV, y'all were pool cameras today for the Corey Richins hearing. Please tell me when you're going to put that on your channel, because I am dying to see it. Dying to see it. We all want to see the Corey Richins hearing from today. So I know you guys were pool out there in Utah while we were all in Idaho, but please, please, please let us know, because we want to see our favorite judge in, I mean, we have a few favorite judges. We don't hold that title back. I mean, from some we do, but we love that judge and we want to hear that hearing. I know some of it was audio only and the court made cameras go off for some parts, but we would love to see it. So thank you. Thank you for coming to the chat and letting me beg and plead for the entirety of the Corey Richins hearing. We would love it. We would love it, Court TV. So hopefully it is on the Court TV channel and we can all direct attention there when it gets put up. And then we will have to all fight in person to have that trial streamed in May, because, oh my goodness. But there was a full hearing and a lengthy one today in the Corey Richins case as well. So good to see you in the chat. We are at the end of the hearing today. Let's try to do a summary because we're going to be back in court tomorrow and we need to let the mods get some rest. It's been a long week of streaming with some long days because, well, avalanche of filings and there's so much more to come. And then we'll have a new Quick Bits on Monday. So let's see if we can summarize what happened today. Also, I didn't mean to scare you off, Court TV, by making requests, but also, thank you. Good to see you. At the end of the public portion of the hearings today in Idaho for the Idaho versus Bryan Kohberger case, we ended with arguments over whether or not there would be a Franks hearing. The defense is asking the court to decide if there will be further evidentiary hearings regarding whether or not there were material misstatements or omissions in the affidavits that led to the search warrants. That is the request for the hearing. Tomorrow we will be resuming, I said that very weird. Tomorrow we will be resuming with evidence in the motions to suppress different items of evidence and, well, multiple different items of evidence. There are so many hearings ongoing because the court set very specific dates in this case, meaning all of these evidence hearings are going to be heard at the same time. A, it's judicially efficient. B, it keeps filings from trickling in. And C, the attorneys get to make all their arguments, reply to all the arguments, and then it's settled. These are items that need to be settled in advance because at the end of the day, The attorneys have impacted me today. At the end of the day, the defense is trying to suppress as much as they can. That is their job. If there were errors in the process, then we will see if that all gets suppressed or not. The court indicated in arguments that he is maybe not super persuaded with regard to whether the DNA that was the subject to the closed hearing this morning will get suppressed. The court is curious about whether or not Bryan Kohberger has the right to argue about how investigators recover evidence from the crime scene, test evidence from the crime scene, run it against DNA databases that don't include his DNA, that he had not submitted his DNA to. And the court asked repeatedly, what is defendant Bryan Kohberger's right to privacy or expectation to privacy in DNA databases that he's not put his DNA into, or in DNA at a crime scene at all before it's identified as his? And they're not arguing, well, he left his thing in this place that he doesn't have a reasonable expectation of privacy in, because of course they're arguing that he was not in the house where the crimes took place. So we will see what happens with these hearings. The court has taken them under submission. This court has been fairly quick with turning around very thoughtful rulings. So we will see what Judge H does. I think that with the IgG, or the investigative genetic genealogy DNA, that the court is not ultimately going to be persuaded. And the court, it doesn't seem, is particularly persuaded one way or the other yet with the affidavits on the search warrant, and asked the defense repeatedly, but if there is DNA, isn't that enough to get us to probable cause? If we have DNA on a knife sheath where there are victims who have been stabbed, and that DNA tracks back to the defendant, isn't that enough for a judge or magistrate to find probable cause for search warrant affidavits? And it seems that that has been the consistent question throughout all of the arguments today. So will there be a Franks hearing? We will see what the judge rules. Unlikely, probably at this point. Will the IgG DNA be suppressed? Also unlikely at this point. And then we get into all the motions tomorrow. So that is what has been happening in Idaho. Yes, lots other is happening in the law, but that's not where we're at today. I'm going to answer a few questions, and I'm going to go so I can eat and rest my voice and be ready for court tomorrow, whatever time court is going to be, or slightly thereafter. A, so we have some Zoom room, and B, so we have well, time for court to start and really skip the lunch break. Kimberly asked, well, let me run to questions, and then I will answer that question, because not today. All of you have asked, are we flying home or staying overnight in Idaho? I don't know. Idaho seems lovely. Boise has some good restaurants. I don't know. I say we hang out, and then we'll see. Well, and then we don't have to fly in the morning. I saw a lot of questions in the chat that there are new filings in the Karen Reed case. I know there's stuff going on in many of the cases I'm covering. There are new filings in a lot of other cases. Am I getting to it today? No. I recorded yesterday and then streamed with the members for 4 hours. We streamed like 7 hours earlier this week, and we're streaming tomorrow. So for the sake of A, my voice, and B, the moderators, not today, but we will cover it. Do not worry. We will cover it. So with that, Donald said, see, you got new lights. I did not. It's just I got a stand desk from Updesk, and so you see a different aspect of my office that has not been on camera before, but I did rearrange some of the books so they would look cuter in the background. I did do that, so it wouldn't be so messy. But we're going to answer just a few of your questions, and then I'm going to go eat. It was a busy day waiting to see when when court was going to be live, because we didn't know, and we didn't know how many witnesses they had because the witness list was sealed. So some of you asking, is it common that things are sealed in a criminal case? Yes. And when we have a high profile case like this one, and I went through this judge's ruling yesterday, when we have a high profile case like this one where they've already changed venue, I think the court is really specifically mindful of information that could get out that could be damaging to finding a neutral and impartial jury that has not had too much information publicly. And the IgG DNA is not going to be evidence in this case. It's an investigative step before they get to other evidence. So it's not something that will eventually come in. And because changing venue again is not going to happen and not even practical, the judge is being mindful, and it's already been sealed multiple times. So that investigative step will not be evidence. And the investigative step is coming up in court to see if it is something that needs to be overturned, something that needs to be suppressed, something that is a problem. We just don't know that yet, though I think we could tell from the court's questioning that they are unlikely. What can come up in trial is where the knife sheath was found, how the knife sheath was collected, how the knife sheath was swabbed for DNA, how that DNA was processed, what that DNA was checked against after the defendant was arrested. Those sorts of things will come up. But the DNA being checked against DNA databases to get to the FBI deciding whether or not they needed to grab trash from Bryan Kohberger's parents' house, that stuff's not going to come in. Other stuff will come in. So hopefully that helps answer those questions. Bulldog Mom says, I giggle when EDB laughs when she's right. It's just when the train of thought is all on the same tracks that it makes when the lawyer brains are on the same tracks, it just makes me giggle, because like if I'm saying the same thing that then is said in court, I'm just like, right, we're all on the same track. Kimberly G in NYC said, EDB, did you say the judge has heard all of this before in an earlier hearing? Is this just for the record? I know she's doing her job and she's good at it, but I'm losing patience with her. The judge did not hear all the arguments before verbally, but he has all of this in writing as well. So the judge has all this in motions, and then the judge heard from witnesses today, and then we heard the arguments on the record. So no, he didn't hear it all, but yes, he knows the arguments that are coming because it's in all the written motions. And he said very clearly a few times, this is an uphill battle. Tina K.S. Leonard, thank you for the gifted memberships. Andrea said, say a prayer for us with the storm hitting Ireland. Andrea, of course, had no idea a storm was coming. Be safe. I can only imagine with how cold it is here in the southern U.S., how cold it must be getting elsewhere. So yes, absolutely. Krista Cree gifted 5 memberships. Thank you. I appreciate it. So thank you. Murphy the dog has an Instagram account. Is that the dog from this case, or is that a different dog? I'm confused. Which dog? But if that's the dog from this case, I'm interested. Wait, is Murphy the dog from this case? Casey Cat said there were multiple teens who reportedly went in and out of the house before police arrived. Who's to say one of them opened the door to check on the dog? I guess we'll find out. The 911 call took a while. And so we will hear more about that for sure. Yeah, we will hear more about that. So Lucy said, EDB, fun fact, the cake phrase is basically Schrodinger's cake. If you eat it, it's gone. So you can't have it at the same time. That makes more sense. You can't have your cake and eat it too, because once you eat it, there is no cake. I appreciate it. But I'm like, has cake wants to eat. The cake is a lie. Really, it just gets back to the cake is a lie. And some of you will get that reference. Some of you will be like, what is she talking about? The cake is a lie. That's the cake is a lie. That's where we're at. Casey Cat, thank you. Thank you for more gifted memberships. That is incredibly kind. And everybody, welcome to the Law Nerd community. Kelly Cal said, I wrote a bench memo for 2L Moot Court on curtilage this year. Look at this. We've been in law school. Look, there's times when you look at law school and you're like, I don't know if this is ever going to come up. And then there's times where we're like, and we're back to arguing curtilage. Yes, these things come up all the time, depending on what area of law you go into. Like, I don't really get into the rule against perpetuities that much in my life, nor could I recite it. But when we're talking about Fourth Amendment search and seizure, I did a lot of search warrant duty in my life. So search warrants, I'm definitely in the realm of my purview of things that we deal with on a regular basis in criminal law. I saw a couple of you mentioning that you were glad for the break from some of the pop culture cases. I will let you know that I will always try to balance both pop culture cases on this channel and criminal cases on this channel. Why? Because sometimes just doing all the criminal cases gets incredibly heavy. It can be quite a lot. And there are times that celebrities arguing over interpretation of things is a different way to get through covering so many heavy criminal cases. So it is always going to be a balance for me because I like the pop culture case. Michelle, I had forgotten about that with BTK and the familial DNA, which is something, but I had forgotten. There are a lot of cases that use IgG. Justin said, my wife, Crystal, won't stop watching your channel. Hi, Crystal. Please be less entertaining. Just kidding. Keep being awesome. I mean, we try. There are days I am definitely more entertaining versus less entertaining. It unless my annoyance is also entertaining, and then we're there all the time. And again, annoyance with the attorneys, because this channel really focuses on what the attorneys are doing, and then we kind of talk about the parties and what the evidence is showing. But the lawyer's lawyering is really the big part of all of this for me. So sometimes I will be empathetic to a lawyer's argument and not the way they are making the argument, or vice versa, or just annoyed with all of them. Just depends on the day. This is an amazing community and I appreciate it. And thank you for everybody being hanging out with me here today, waiting for the court. Lawyer's daughter asked, what if a phone number shows up on a victim's phone? That can be the basis to get a search warrant for the number that shows up. You don't always need a warrant for a victim's phone. It really depends on the circumstance, but you don't always need a number for the victim's phone. And sometimes things are in plain sight. Like if you're talking to somebody and a phone number pops up and you see it, sometimes that might be plain sight. It's going to depend on where we're at. So let's see. There are a few more that I grabbed. Tammy E said, don't need a warrant to search trash once it's on the curb. It's public. It is. It was unclear to me until we went through the hearing today where the trash was located in Pennsylvania. And they cleared that up today. I hadn't seen that anywhere else. And Desiree in the chat said, Warren was at an event you were at. You got to see Warren in real life. An Octo sighting is always very, very exciting. Like an IRL Octo sighting is good things, Denise. So I'm glad to hear it. And I'm glad you went up and said, hi, I'm sure he did too. So yay for Octos in the wild. It's fantastic. So thank you for sharing. I love that. And let's see, what else? What else have we got? Thanks for the free airline lounge day pass, Anne. You are welcome. Don't worry, all of you that have said, hey, we are looking for travel related things. Don't worry. We are planning things out in advance for the Law Nerd shop. So do not worry. Do not worry. We've got stuff for you. We've got EDB Air stuff. Nikki said EDB Air, like traveling from the comfort of home. Nikki, I think that might be our motto. Like traveling from the comfort of home. Exactly. I also saw questions on the chat in the chat if I will be going to Idaho for this trial. No, I will not. Though Idaho is lovely, I'm going to be home streaming it. First, because if I am in court listening to it, I have to watch the back of everybody's head except for the jurors. I want to see everybody's faces and stream it here with y'all. So no, I will not be in court. Will I be in court for other cases? I can't make any promises. I don't know. Do I like streaming? Yes. It's like with, I've gotten a lot of questions. Oh, what case is going on in LA right now? My brain just absolutely stopped. The ASAP Rocky case that's going on in LA. It's not going to be televised. It's really hard to cover cases when we have to rely on media reporting. But if there was ever a case that I wish was televised, I would be interested in the ASAP Rocky case. One, because I like that judge, and two, because I like that prosecutor. But that's also a case that I just want to watch because I know the people involved with the court staff. But that's a John Lewin prosecution out of Los Angeles and Judge Arnold's court. So I'm sure some people will be in there, but we have to wait and see what the reports are coming out. And it's much harder to cover cases from reports. You know, y'all remember the LA Times said that Jason Momoa testified in the Depp Heard case. This is why I get a little cautious when we are covering just from reports from court. I tend to wait. I prefer being able to let's watch it all come in. Or if there are accounts that are great that are giving you kind of a verbatim like we get in the Diddy case, that's very helpful too. But just going with summaries, it can be difficult, but I will keep an eye on it. So with all that, Law Nerds, it has been great to see you today. I hope you had a great day. You guys are saying it is live streaming? I'll take a look. Because if it is live streaming, I will take a look at the days. I didn't think it was. Maybe it's not just streaming for jury selection. I'll take a look. I didn't think that it was because Lewin is hilarious. Lewin is hilarious in trial. So I'll take a look and see. But I will take a look and see. So thank you, chat. I will keep an eye. I will keep an eye because Lewin. Because Lewin. All right, Law Nerds. Thank you for being here. Thank you for being Law Nerds. I will see you tomorrow. Do I know what time tomorrow? No, I don't know what time tomorrow. Why don't I know? Because the court didn't say yet. So I'm going to have to wait till it pops up on the docket. I am presuming they are starting around 9 a.m. Mountain Standard Time, which will be about 10 a.m. my time. And we'll probably give a little bit of zoom room from that. So likely around 10:30 tomorrow morning. I will let you know in the app at lawnerdapp.com. Lawnerdapp.com. Download the app. I will keep you in the loop when we're going live in case anything changes. I haven't seen it on the docket yet. So when I see it, I'll let you know. Law Nerds, we out. Mods, thank you so much. You guys are the best. Thank you, Team Baker. I'll see you guys tomorrow for court. Court's in session tomorrow. Everybody, don't be late. I mean, asterisk, late is a construct, time is a construct, and you can rewind streams, which is why I love streaming on YouTube. So whenever you get here, you won't be late, and I'll see you then. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.